Good morning, everyone. I'd like to call the June meeting of the Charlotte County Board of Zoning Appeals to order. First thing on our agenda is, if you could please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. If I could ask Diane to conduct a roll call.
William Abada-Mateo.
Here.
Steve Vieira.
Here.
Larry Fix.
Here.
John Donner. Here. Blair McVetti, absent.
Thank you, Diane. And Diane, can you swear everyone in who will be giving testimony today?
If you're going to speak, please stand. Raise your hand. Do you swear or affirm the testimony you're about to give today is the truth? If not, or if so, answer, I do. Thank you.
Yeah. All right, thank you. All right, next on our agenda is approval of the minutes of the May 11th meeting this year.
Okay, I request that the approval of the minutes of May 11th, 2022 be approved.
I'll second.
We have a motion's been second to approve the minutes of our last meeting on May 11th. Any discussion? No. All right, then we'll proceed with the vote. All those in favor of approving the minutes as submitted signify by saying aye.
Aye.
Any opposed? All right, the ayes have it. All right, next is introduction of staff. We'll start with our zoning official.
Thank you. Good morning, everybody. Sean Cullinan, Planning and Zoning Official. Today we have 2 variances and 2 special exceptions. The Board of Zoning Appeals is empowered to grant special exceptions and variances to the zoning code and hear appeals from decisions of the zoning official upon showing that all required criteria have been satisfied. Generally, the variance process is intended to provide limited relief from the requirements of the zoning regulations in those cases where strict application of the requirements will create a practical difficulty or undue hardship as distinguished from a mere inconvenience, prohibiting the use of the land in a manner otherwise allowed under the zoning regulations. A variance is intended to provide relief in limited circumstances where the requirements of the zoning regulations render the land difficult to use because of some unique, exceptional, or extraordinary physical attribute of the property itself or some other extraordinary factor of the property for which the variance is requested. A variance shall be granted only if all 5 of the approval criteria are found to exist. In granting a variance, the Board of Zoning Appeals may impose such conditions and restrictions upon the premises benefited by the variance as may be necessary to allow the positive finding to be made on any of the foregoing factors or to minimize the injurious effect of the variance. Generally, a special exception is permission for a use that would not be permissible generally or without restriction throughout a zoning district, but which, if controlled as to area, location, relation to the neighborhood, and other such restrictions as may be deemed appropriate in each case, would be compatible with the surrounding land uses and found to be consistent with the comprehensive plan for Charlotte County. A special exception shall be granted only if all 3 of the approval criteria for special exceptions are satisfied. Thank you.
Thank you, Sean. Next, we'll hear from our legal department, Mr. Tom David.
Good morning, Mr. Chair. The Board of Zoning Appeals is a quasi-judicial body. This means that all interested persons have a right to be heard and present evidence. This board has no authority to change zoning regulations, nor may it rezone property. All decisions of this board must be based on the evidence presented to it. Only competent, substantial, sworn, factual evidence and expert opinions, if offered and accepted, may be properly considered by the board. All documentation presented to the board or county staff will be retained as part of the official record of proceedings. Decisions of this board must be by a majority vote. Tie votes do not carry the motion made. If an application is approved, there may still be other approvals or permits required before any development activity may commence. Please consult county staff in this regard. Deed restrictions are private agreements. This board does not have the authority to consider, modify, or rescind them. Judicial appeals must be made to the Circuit Court within 30 days of written decision by the Board of Zoning Appeals. Thank you.
Thank you, sir. Again, I'm Bill Abada-Mateo. I'm Vice Chair of the Board of Zoning Appeals. I'm filling in today as Chair, as our Chairperson, Blair McVetti, is out of state. Let me just explain the order of proceedings and how this works for those of you that may be here for the first time. The county staff will make the initial presentation for each request. Then the applicant or the applicant's representative shall then make their presentation, present any evidence, and answer any questions board members may have. Then after the applicant, any interested persons for or against the petition will then be invited to testify and answer any questions board members may have. We have a time limit of 3 minutes for comments, and you'll be notified of that. All persons shall have the right of reasonable cross-examination of witnesses. The applicant or applicant's representative shall have the right to present any rebuttal evidence and make any closing statements. Then the county staff shall have the opportunity to present rebuttal evidence and closing statements, after which time the public hearing will be closed, except that the applicant or applicant's representative may present additional rebuttal evidence relevant to the county staff's closing evidence and statements. That's the order of proceedings. For those that do come up and speak, please note that there's a line tablet at the podium. We ask that you print your name and address on the tablet prior to speaking, so we have a record of who came and spoke for or against any petition.
Sir, no questions are accepted from the audience at this point. Thank you.
It was just in regards to what...
Sir, there's no questions, no commentary from the audience at this point. Thank you.
as far as procedure?
Sir, there's no commentary from the audience at this point. Thank you.
When you have printed your name on the tablet, please state for the record your name, address, and the fact that you have or have not been sworn in. All persons desiring to speak must be sworn. Now, if you weren't sworn in when Diane asked you to stand and swear in, just let us know and she'll do it at that time. And if you have a question, maybe at that time it would be appropriate, we could respond, but generally we don't respond back. All right? You're giving testimony, you're presenting evidence. All right, moving on to new business. We have 4 petitions today, as the zoning department had mentioned. They were advertised on May 21st, 2022, meeting the criteria for public notice. We have two special exceptions and 2 variances. Sean, we talked about in order of proceeding.
Yes, sir. What we would like to do, some of the less contentious items we would like to get out of the way first, so those folks aren't here waiting. So with that, we'll start with special exception 22-12.
Okay, and if there's no objection from the members of the board, and this is typical what we do, the special exceptions and the other variances go pretty quickly. And if it's appropriate, you can summarize the county report if you choose, rather than having to read the whole thing, which is pages long, at your discretion.
Yes, sir.
Right then, which one did you want to proceed with?
We will start today with special exception 20-012. This is for the Port Charlotte Church of the Nazarene.
Okay.
Ready? All right. Sean Cullen, Planning and Zoning Official. I have been sworn. At this time, I'd like to offer myself into evidence as an expert in planning and zoning matters. I have over 15 years of planning and zoning experience, with the last decade being the Planning and Zoning Official for Charlotte County, and respectfully request to be deemed an expert. With that, the first item, special exception SE 2212. Ms. Veronica Martin, agent for the Port Charlotte Church of the Nazarene, is requesting a special exception to modify an existing special exception granted in 1996 to allow the expansion of a school as part of a place of worship in a residential single-family 3.5 district. As you can see, this was properly advertised. This is the 1,000-foot buffer location map. This is the high aerial location map of the location near Midway, Lakeview. The zoning designation for the property, as stated, was RSF 3.5, and here is a closer area image. Here is the most recent Google Earth image as well. This is the proposed layout. This will add another building for approximately 30 more students to the existing school that is there. With that, staff has reviewed this in light of the proposed criteria for finding of compatibility, and staff recommends with the conditions 1 through 6, find that it would be compatible with the codes and ordinances of Charlotte County, and would be happy to answer any questions.
Okay, does anybody have any questions of staff at this point? All right, hearing none, then can we have the applicant or the applicant's representative come up to the podium? And please sign in and then state your name. Okay, have you been sworn in?
Good morning. Yes, sir, I have been sworn in.
Okay, go ahead, proceed.
My name is Veronica Martin. I'm the senior planner with TDM Consulting located at 43 Barclay Circle, Suite 200, Fort Myers, Florida, 33907. I do have a very, very brief presentation. I am representing the applicant, which is the Port Charlotte Church of the Nazarene. We are in agreement with the staff report that has been submitted to you and the 6 conditions of approval. I just want to touch base on a few of the key critical items. The Genesis Christian School is a parochial school for children K through 8. The existing school does allow a maximum of 155 students, with 128 students enrolled in the 2021-2022 school year. The expansion request will permit a maximum of 180 students. There are 9 classrooms in the 4 existing modular buildings for the K through 8 students. The proposed 9,293 square foot modular building will also provide 9 classrooms, bringing the total to 18. Although the number of classrooms is doubling, the expansion will only permit 180 students for smaller class sizes. There is an existing fenced-in playground on the property. No additional playgrounds or ball fields are proposed with the expansion. The development currently uses potable water and a private septic system. Expansion of the school will require a new septic and drain field. The site is heavily wooded to the north, providing a large buffer to those residences to the north, east, and west. A site permit will be required for the expansion, which will require 8-foot wide perimeter buffers along Helena Avenue and Verona Street. And those buffers are actually one of the conditions of this special exception approval. Dean Martin, the professional engineer with TDM Consulting, did prepare a traffic memo using the ITE Trip Generation Manual 11th edition, volume 5, for elementary schools. This study did compare the current enrollment of 128 students with a maximum enrollment of 180 students. That creates an additional 53 trips in the peak AM hours and additional 14 trips in the PM peak hours. The small number of trips created by the expansion will not have a detrimental effect on the current level of service of the surrounding roadways. We do meet the 3 criteria, and again, we are in agreement with the 6 conditions of approval. That summarizes my little brief presentation. I can answer any questions you may have.
Do you accept staff as experts, witnesses?
Absolutely.
Does anybody have any questions?
Yes, I do. For the perimeter, we have an 8-foot wide landscape area. Is that what's being proposed around the site?
That is correct.
Okay, and is there any type of fencing that's also included in that landscape area?
That is not a requirement of the code because they have plenty of space and the vegetation is enough. Should they want to fence it for security reasons for the kids or anything, that would be completely up to them, and that would be allowed per the code.
Okay, thank you.
Right, no more questions from the members of the board. Thank you for your presentation.
Thank you. I'll be able to answer any questions you may have afterwards as well. Thank you.
At this point, I'd like to open the public session. If anybody has any comments for or against this special exception, please come up.
While she's coming up and signing in, we did receive an email late last evening, 10:42, from a neighbor, so I'm just going to pass that out.
Okay. Thank you.
I've prepared some data for the board members. May I bring it to you, please?
I'm sorry, I can't.
I've prepared some data for the board members. Thank you.
And again, can you state your name?
My name is Nancy Becky, and 4 months ago, I bought the property across the street from the woods that is in question to be zoned, or is preparing to be zoned for the school.
Okay.
Okay. First thing, the woman that just spoke said that there would not be an issue with the roadway with the additional traffic. I would like to invite the board members before making a decision, or the zoning officer before making a decision, please travel that roadway and decide that for yourself. The roadway is very narrow, and it's already an issue with the traffic from the school. Expand the school and the traffic, and it's definitely going to be an issue. Also, there's a massive pothole right around the corner. It's a very severe corner on the roadway, and there's a pothole right after that corner. And I live on that corner, and I hear cars hit it constantly. Additional traffic is only going to make it worse. The data that I've prepared shows you how many students there are in Charlotte County for the 21-22 school year, how many teachers were employed, and what the ratio is for students to teachers. There is not a shortage. There's no need to build more schools. If that property is rezoned, you're going to rezone all of the property, and I'm told that only part of it is going to be used to build the school. But if all of it's rezoned, what is to prevent the rest of it to be built on in the future? And like I said, I just bought the house across the street. It's going to destroy the property value in the neighborhood. That's all.
All right, and in response, we just, I heard what you said. We don't rezone. It's already zoned. We don't have that authority. Rezoning takes place by the zoning board with the final approval of the Board of County Commissioners. The way it's currently zoned, a school is permitted. It just has to meet certain criteria to be that special exception. So we're not rezoning. And also it comes with restrictions. If it is approved and the criteria it is, the special exception is specific for this purpose. And they can't go beyond that. If they did, they'd have to come back to us. All right, I just wanted to clarify that. Okay?
Thank you. And thank you for your time.
All right. Does, any members? All right. All right. Anyone else?
For clarification, these trees here, none of those are being removed. This new structure is going right here next to the existing 3 classroom structures between the existing church facility and the 3 school structures. So it's going in the middle. There may be an internal tree removed, but all the vegetated area up here is not being touched.
And Sean, did staff do a site visit?
Yes, sir. When we go to post the sign, we obviously scope out the facility, look at all of those things. If there's a pothole, those obviously pop up quite frequently in various locations. She can contact Public Works, and they would be happy to address that.
Okay.
Maybe not happy, but they will address that.
Thank you. Yes, sir.
My name is Victor Vi. Can I be sworn in, please?
Do you swear or affirm the testimony you're about to give is the truth? If so, answer I do.
I do.
Did you sign in?
Yes.
I wasn't watching, okay.
I had a question for, I guess, Ms. Martin, who came up here and told us, did I hear correctly, it's a 9,000 square foot building?
We can bring the witness up afterwards, so if you'll state your question for the record, we'll have them come up and answer the question.
So existing portables there are pretty much a classroom-sized portables. That's what I call them. So a 9,000 square foot building, if I'm correct with that, is not just another portable. That's a good-sized building. And my question is, I don't exactly know where that is in relationship to those portables, but to get to it, are they going to have to cut another road into it, is my concern. Plus, how big is the building actually?
Well, that would be part of the proposed site plan. Sean, do you have any?
Yes, and I apologize, I misspoke. I was looking at the middle portion that's under this tree that's hidden. Actually, the structure is going right here in the front, where it's already no vegetation. So there is not a proposed second roadway. The way it comes is folks come in one way. There's an access here on Verona Street, I believe that is, and an access here on Helena, and they just do a big loop. So there are no secondary or third road cuts proposed.
So this is basically going to the east of the sanctuary building?
South, it appears. There's no arrow on here. There's an arrow on this one. Yes, it's to the south. This is the sanctuary building right here, this L-shaped structure. It's going right in front of there. I apologize. I had thought that was a parking area. It's very small on our visuals. So you can see that here.
Okay, thank you.
All right, thank you for your question. Anyone else? A second call for anyone else for input? Okay, at this point then, can we have a motion to close the public input?
Move to close public
hearing
input.
be closed.
We have a motion. Has it been seconded?
Second.
Okay. Motion on the floor has been made and seconded to close the public input. All those in favor?
Aye.
Any opposed? Okay, public input is closed. Next, back to...
Thank you. As stated, unless the applicant has any rebuttals.
I think we ought to invite the applicant up to respond to the question.
Did the applicant want to come back up and any additional comments, or if you wanted to respond to any of the public's concerns?
Sure. Again, for the record, Veronica Martin with TDM Consulting, representing the applicants. Part of our presentation and submittal application did include a floor plan of the modular building. It's 9,283 square feet in size. It does include 9 small classrooms. Each classroom will have its own restroom facility and storage areas, and of course the hallways and things like that. There's plenty of parking on site. The church and the school do not operate at the same time, so they'll use the same parking. We're only providing additional sidewalks to access this new building. There will be no additional roadways. I think that answers the gentleman's question, but if there's any others.
Anyone on the board have a follow-up question? All right.
Right.
Well, thank you.
Thank you.
All right. Sean, you're on.
Thank you. As stated previously, staff finds that this could meet the requirements of the comprehensive plan and land development regulations. We have 6 recommended conditions of approval, and it is up to your discretion how you would like to proceed, sir.
Okay. Did you want to read the recommendations into the record?
If you'd like that, I can. The first one is the special exception as approved is to modify an existing special exception to allow the expansion of an existing school as part of a place of worship. Extends only to the lands included in the site plans and legal description submitted. Number 2, the concept plan submitted by the applicant as part of the petition is for illustrative purposes only. All applicable regulations of the code shall apply to this development. The applicant shall obtain all necessary permits and approvals, including but not limited to site plan review, landscape plan review, stormwater, septic, transportation, and building permits. Number 3, perimeter landscape strips shall be planted along the rights-of-way of Helena Avenue and Verona Street. Existing vegetation may be used to meet this requirement. Number 4, any additions of outdoor recreational uses, including sports courts or ball fields, will require modification of the special exception. Modification or renovation of the existing playground does not require modification of the special exception. Number 5, the special exception is granted for a term of 5 years from the date of approval of the Board of Zoning Appeals. However, the special exception shall not expire if the owner commences the proposed development on or before that expiration. And number 6, any major changes or additions to this special exception shall require modification of the special exception. Minor changes or deletions, such as accessory uses or structures, may be approved by the zoning official. Thank you.
Okay, thank you. Any follow-up questions?
Yes, I have a couple. I'm personally concerned about the security. We're looking at about 350 students, and most of Charlotte County schools have some sort of perimeter fencing and or other security measures. Now, I realize that this is a private endeavor, but I'm uncomfortable with the fact that we're not asking the applicant to provide some sort of security measure for this project. I think it's prudent in today's society that we at least take a look at that. I know we still have to go through a site plan review process, but is it within the purview of this board to suggest that we include some sort of a security feature on this property?
So you can make a recommendation. That's as far as you can go.
And with respect to the number of students, full capacity would only be 180.
Can you clarify that? Because there's already an existing number of students at
Correct.
the facility, and we're adding, are the existing portables then going to go away and everybody is going to contain in one unit?
That would be a question for the applicant. Currently, they have a maximum capacity of 155 students with a current enrollment of 128. This would allow the school to expand their capacity to 180. So that's how many they would have total.
All right. Thanks for the clarification.
So as I understand it, they already have capacity for 155. This will increase it by 25, up to 180. Is that correct?
Yes. And it also gives more room for the existing students to have more space for other classes, things like that.
Right.
I guess I'm still confused by the math. We have the capacity. What's to prevent utilizing that new 9,000 square feet and maintaining the existing square footage in the 4 modulars and increasing the student curriculum, or I'm sorry, not curriculum, but the student capacity on the site? What's to prevent that from happening?
There is nothing. I believe student to teacher ratios, things like that, those are all regulated through the state. This would have, we don't regulate the number of students because we'd have no way of following that. Again, just like Charlotte County Public Schools have a maximum capacity in their facilities, they may not have the full enrollment to hit maximum capacity. Same thing here. They have a maximum capacity of 155. Their current enrollment is 128. Today, they could have up to 155. This will add those 25, the ability to have 25 more students to cap their enrollment, or to cap their maximum capacity at 180, and that's per them. That's per their application.
Is that existing 180 capacity based on the previous special exception that was given to the church to have the school in the first place?
There was no capacity limitation in the first one. It was for the use and the structures on the site.
And what they could staff or?
Correct.
Steve, you raised the issue of security. Is that, are you satisfied, or you asking for something else to be added?
No, I'm not, to be honest with you, because my questioning is that there seems to be no way to prevent the applicant from increasing the number of students on the site to maximize the square footage that they have available to them. In my mind, that sets up a situation where you could have a security issue. And that's was the beginning of my questioning, was that if we could have, if the student ratio is 20 to 1, as close as I can figure out in the classrooms, we could have 300 plus students on the facility. And somebody gave us a document that said that there were a maximum amount of students in different schools around the area, and that 300 matches up with several other schools that are close by, and all of those schools, although it's Charlotte County code or school board code, whichever, has security measures in place. So I'm just trying to rationalize in my mind, if I give an approval to this subject, that there's going to be some sort of a safety factor involved for the eventuality that the number of students will increase on this site.
Understood. You could put a condition in limiting the number of students, but again, that's very difficult. Staff does not have the ability to go out and track their enrollments, nor do I think we'd want to get into that, just like we would not do that with Charlotte County Public Schools or any other, but you do have that authority.
Well, I'm comfortable with the 6 recommendations. I'd like to see some sort of a caveat, maybe a 7th item that has a security provision, whether it be directly around the existing and proposed building, not the entire site, but around the building, just from a security point of view. I think it's prudent.
Can you elaborate? When you say security, that's a general statement. Do you have something in specific?
Sure, I'm talking about some sort of a fencing scenario, yeah. Just like the rest of the Charlotte County schools have. They all have some sort of a security perimeter. And in some cases, I think in all cases for the county, there's an access gate to get onto the property, except for during the times of school entry and exit at the beginning and the end of the school day. So I'm just looking forward.
Mr. Chair, maybe it would be appropriate to recall the applicant's witness to address this question. You know, there may be a financial reason they're not able to do that, but.
Sure. Can we have the applicant come back up, please?
Again, for the record, Veronica Martin with TDM Consulting, representing the Port Charlotte Church of the Nazarene. The subject property is 10.3 acres. To fence and gate the entire property would be financially infeasible for this small parish and the small school. It is, again, a private Christian school, and the handout that Miss Becky had submitted, the students for private schools are in the same category, 177 for St. Charles Borromeo School, 157 for the Charlotte Academy. So I think the number of students is in keeping. I don't know how they would fence and gate property that has a dual purpose for both the church and the school. And in addition to the new structure, the new septic in the drain field, and the perimeter buffers, and any other site improvements that will be required at time of site permit, even if they fenced and gated half of the property, which would be 5 acres, I still think it would be cost prohibitive.
Any questions?
Could you establish security of locking doors and stuff like that?
I'm sorry, I didn't hear you.
Locking doors, all those doors to be locked when school's in session?
I'll be honest, I did not ask the church or the school themselves if they have security measures existing on site. I do know that every child that I know that attends school, they do have security measures, whether it's a public or private school. So, but again, I didn't ask specifically that question, so I apologize.
And Sean, you know, other than buffers for aesthetic, noise, and so forth, do we have authority to get involved in security of any applicant, you know, to prevent injury, theft, vandalism, fire? Is that, I'm not sure if that's within our purview.
Right, I would defer to Tom, but you do have the right to place conditions that will make the proposed use compatible with the surrounding land uses and structures and be consistent with the code and the comprehensive plan.
I mean, this is a difficult question because the code does not require the fence. So the buffer is required, and maybe that's something that the code ought to consider, but it does not consider it today. However, one of the criteria for approval of special exceptions is that the establishment, maintenance, or operation of the proposed use shall not be detrimental or endanger the public health, safety, or general welfare, which is a very broad concept. So, you know, really, this is something for you to weigh. Unfortunately, I think the board has to look at it. We do not have, though, in the code the requirement for security fencing. So, the basis you'd have to apply it is that last component when you weigh whether to approve or deny, essentially.
I'd like to ask one question.
Certainly.
When you set up your school, were there any state approvals or inspections involved?
There's always state inspections. They have to meet the state criteria for education.
Okay, well then the state apparently approved what you have and how it is secured.
Correct.
And I would think that it's not our business to be involved in that.
In the schools that I've been in, most doors lock behind you and they only have the push bar. So it's exit only, and then you have to have the keys to enter in a traditional way. So.
I'm just curious, in the county, do private schools, do you have school resource officers on site?
I did not ask that question, so I can't answer. I apologize.
I was just curious. All right. If no other questions, thank you.
Mr. Chair, I'm willing to move on with the approval of this or a motion to approve. I would just request it as a matter of record that at site plan review, staff takes a look at what security measures are going to be made for the classrooms, existing and proposed.
Yes, sir.
And we have a motion on the floor to approve it with the 6 recommendations and the additional caveat.
I'll second it.
All right, second it. Any discussion?
It's all has been discussed. It's all has been discussed.
Let me just state for the record that the wisdom of any business coming before us, whether it's needed, whether it's profitable, it's free enterprise, that is not part of our criteria in determining whether any business coming before us, you know, if somebody wants to open a business and it meets the zoning laws as an exception, that's up to them whether it's going to be profitable or not. We don't sit here in judgment whether a gas station is needed, whether another barber shop is necessary, or will it be profitable. And that same principle applies to the private enterprise of a school. We cannot sit in judgment of that, just to let you know.
Need to hold a vote.
Yes. All right. If there's no more discussion, let's move the question. All those in favor of approving this special exception signify by saying aye.
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 Any opposed? All right, the ayes have it. Special exception is approved.
Thank you. The next item is variance 22-004. This is for 1330 River Lane. Ms. Deborah Hughes is requesting a variance to allow a 6-foot tall fence in the required 25-foot front yard setback in the residential 3.5 zoning district. Here is the 1,000-foot adjacent property owner notification buffer map. Here is the general location map. The zoning designation, again, RSF 3.5. The area image. And a closer in, as you can see, this is Farlow's on the Water restaurant. This is their existing parking lot. and they have just gone through a plan development rezone to add another parking lot right here. They purchased these two properties. Here is the Google Earth image. Here is the site plan showing the fence going up all the way to the property line. Oh, wrong side. So she'd like to go up that way and that way. Here is a street shot of it from her property line. And with that, there is one criteria that staff finds that this does not meet under the 5 criteria, and that is the criteria number 4. The condition giving rise to the requested variance has not been created by any person presently having an interest in the property, and the conditions cannot reasonably be corrected or avoided by the applicant. The applicant did put up the fence in this location. There was some confusion, I think, on the part of zoning staff when reviewing it as to where it was going, whether it was staying within that 25-foot setback or not. Regardless, it has been constructed. The applicant's here. Should you find that this does meet the requirements for a variance, then we have 3 proposed criteria for conditions. With that, I'd be happy to answer any questions, and the applicant is here as well.
Does anybody have any questions of staff? All right, thank you, Sean. Can we have the applicant come up? And again, sign in and then state your name.
Good morning, gentlemen. My name is Deborah Hughes, and I live at the subject property now for about 7 years. First, let me begin by asking, does anyone have any questions of me? Briefly, there was a time on the other side of the 6-foot fence that I had a neighbor who was a hoarder, and he was the subject of maybe 3 or 4 dozen code violations. There were liens put on his property. He had a junk condition yard. To be honest, where the 6-foot fence is now, there was only a 3-foot fence, so I sought a permit to construct to make it 6 foot tall, just 2 more panels, 6 foot tall, there at the end there. And that permit was approved. I bought the construction materials and I hired someone to put up the 6-foot panels for me, and it was inspected and it was approved. I know there was some confusion, as Mr. Sean said, on behalf of the inspection staff, whether or not there was a modification by me, but that simply didn't happen. It gave rise to a complaint that my fence was too tall. And I take the position that I have never modified it, but I in no way wish to be out of compliance with the code. I wish to rectify it, and that is why I suppose I could have sought to fight the matter, but at the end of the day, my property is not in compliance with the code, and that I wish to rectify. Now, Mr. Keith Farlow is building a parking lot just on the other side of my property, and I'm glad that they are, because that property has been completely cleared up, but there is additional noise over there. I've put some bushes along that fence to help defray the noise, but they're kind of small now, but hopefully they'll get bigger. I would very much like to keep it that way. Of course, you could see I put a garden in there, but the fact that the criteria regarding whether or not no person caused it or I caused it, my position would be I didn't cause it. I mean, I sought the permit and I tried to do this lawfully. The permit was approved, the construction was done, the inspection was approved, and it was later, a complaint was filed later by the hoarding neighbor that my fence was too high. So there you have it. I do very much wish to rectify the situation. So if you have any questions for me, I'd be glad to answer them.
Any questions?
Good.
Okay, thank you.
Okay, thank you.
All right, is there anyone from the public that would like to speak for or against this? Any evidence you want to provide?
I'm sorry, sir?
No, I'm asking,
Oh.
we'll open the public input section, and is there anyone that wants to come forth and provide any testimony or evidence for or against this petition?
And staff has not received any letters or mailings in opposition.
Okay. Like to come up? Sure.
My name is Nancy Hendrick, and I just was listening to her story. I think it's really unfair for what she has gone through. Yes, I was sworn in, yes, when I stood up. For what she's going through, because again, she got the permit, she got the whole job done, and then listening to her and looking at that picture, and for her to go down on size on 6-foot fence to see a parking lot, and then to see another parking lot. I mean, she's right in between two parking lots there. I just think it's unfair for her going through all that. She paid all that money. She, you know, she looks like she's a nice lady here. I'm just saying is that it's pretty unfair for her and to look at two parking lots as we all are in our property values. And we all know what our property values are. And things like that is going to reduce her property value on two sides. I mean, she looks like she has a nice house. Have you been there a long time? 6 years, 7 years, yeah. I mean, I just in favor of her, and I think that you should just swipe it clean. And that's what I have to say.
I'll sign in a moment. My name is Jerry Waxler. I am with the McCrory Law Firm. I am a land use attorney, but I am not representing the applicant or anybody in opposition. I just wanted to clarify something. While evidently from the testimony, there was a fence that was permitted at 6 foot. There was a mistake made when that was fenced. Sean has characterized this as, therefore, the situation giving rise to the variance is of the applicant's own creation. I think there's another way of looking at it. The situation that gave rise to the putting up of a fence and the need for a 6-foot fence is the construction and the activity that's now going to be going on immediately adjacent to her property, where she's going to be adjacent to a parking lot and to the noise that is attendant with that parking lot and to the visual impacts from that parking lot. The 6-foot fence is necessary to address that, and I think it would be within the purview of this board to be able to find that the situation giving rise to the need for the 6-foot fence, which is what the variance is being requested for, was not of the applicant's making. Thank you.
Thank you.
Anyone else? Second call, anyone else for any input? All right, hearing none, can we,
Request the public hearing be closed.
all right, any second?
Second.
All right, we have a motion to close and second it to close the public input. All those in favor?
Aye.
Anybody opposed? All right, so it's closed. All right, did the applicant want to come back up? You're welcome to if you wanted to respond to anything anyone said.
No, thank you, sir.
Okay. All right, so Sean, you're on.
Thank you. Should you find that it does meet the criteria, we have 3 recommended conditions. That would be, number 1, the variance as approved is to allow a 6-foot tall fence within the required 25-foot front yard setback. The variance shall only apply to the existing fence as shown in the document submitted with this. And number 3, if the 6-foot tall fence is removed or replaced, the variance shall expire, and all future development must be constructed according to all applicable codes in existence at the time unless a new variance is granted specific to the development proposed at that time. This condition shall not apply to removal or replacement caused by a natural disaster or involuntary involuntary destruction of the fence.
Okay. I have a question. Fencing in time does need to be replaced. They do wear out, maybe it's panel at a time. Would that then void the variance, the way it's worded?
The way it is worded, yes. A vinyl fence, it has a pretty long lifespan, probably a good 15, 20 years at least, if not longer.
And with the parking lot going next door, they're going to have some requirements, aren't they, for?
That is correct. They are actually required a fence or wall as well with landscaping, trees, shrubs, all the required landscaping.
Mr. Chair, you could delete or replace from paragraph 3, and that would allow them to replace the fence.
Yeah. I'm just thinking with normal wear and tear.
Sometimes they get damaged too, so.
Sure.
I've seen cars go through fences, so.
That would most likely fall under involuntary destruction of the fence.
Maybe.
Staff have any comments or objections if we remove that?
No, sir. This is one of those
Replaced.
situations that happens occasionally. It's well within your purview to grant how you so choose.
We have a motion then?
Okay, I request that move that variance 22-004 be approved. Based on the Community Development Department staff report dated June 1st, 2022, the evidence presented at the hearing finding that the applicant has met the required criteria for the variance as listed in recommendations 1, 2, 3, and would like to change number 3 to remove.
Delete or and replaced.
Move or replace. And number 3.
Okay, any second?
Second.
All right. We have a motion on the floor to approve it with the modification of the third recommendation or requirement, and it's been seconded. Any discussion? All right, we'll move the motion. All those in favor of granting this variance signify by saying aye.
Aye.
Anyone opposed?
Aye.
What was that?
No, I'm not opposed.
Oh, okay. Variance approved. Thank you.
Mr. Chairman, if I could just remind the audience that the board rules do not allow for exhibitions like clapping, et cetera, and we understand your exuberance, but it does interfere with the process of the hearing.
Okay, our last variance, petition 22-005.
Thank you, Sean Cullinan, planning and zoning official. I haven't sworn. This variance is a request for a rear setback variance located at 3225 Magnolia Way. This is just outside the Punta Gorda city limits. Michael and Dorothy Neal are requesting this variance to the required 15-foot rear yard setback by 5 feet to allow for a 10-foot rear setback for a new swimming pool and deck. Here is the high aerial. Again, the zoning designation RSF 3.5, and you can see the city right next door to it. Here is the area image, and here is the closer in aerial, the Google Earth image, and their survey. Due to erosion, over dredging, whatever it might be, the property has been reduced by about 9 to 13 feet. As you can see, it's on an angle, so it's not easy to give an exact number, but the shortest side here is about 9 1/4 feet from their platted property line out into the canal. It is now seawalled. They are therefore requesting this variance in order to build a pool. The house was built in 1986. Here are some photos of the existing property. So with that, staff finds that this may meet the 5 required criteria for the granting of a variance. Should you find that it does, we have 4 recommended conditions, and I will read those in after you have your discussions and public comment. I'm happy to answer any questions, and I believe the applicant is present as well.
Okay, does anybody have any initial questions of staff? Okay, could we have the applicant come up, please?
Good morning. My name is Michael Neal. I live at the residence in question here. It is our desire, as stated, to reduce the setback from the canal from 15 feet to 10 feet in order to put in a swimming pool. At its current state, it would only allow for a 5-foot wide swimming pool with the available space. We request the additional 5 to make that a 10-foot wide pool. We believe with that request, we're asking, again, just for a modest amount in order to make a reasonable size accommodation for a pool.
All right, have you read the recommendations?
Yes.
By staff, okay, and you accept Sean as an expert witness?
Yes, I do.
Okay. Does anybody have any questions of the applicant?
I do, just one. Just for clarification, on the survey supplied, it shows, the existing survey shows 2 davit bases. Are those going to be removed for the pool construction, or are they going to remain in place?
They would remain in place.
They would. Thank you.
Okay, any other questions? Well, thank you.
Thank you.
All right, now's the time for any public comments or input. If anybody would like to come up and give testimony or evidence for or against this petition.
Do I write my name again?
Yes, just state your name again for the record.
Nancy Hendrick. And just listening to what he was trying to do is to put a pool in place. And then what he was saying about the erosion that came upon and lost, some of the property already. Oops, sorry. And I know everybody wants a pool. I'm a full-time realtor, but I know I'm not supposed to say that, but I understand what he's trying to do is because of the setbacks that they have on any of the homes that are close to the water. And when it's 15 feet, is that what he said, 15 feet it needs to be? Yes?
Correct. The setback to water is 15 feet from the mean high water line.
All right, because that's interesting is because I thought it was only 10 feet myself. So I thought it was only 10 feet from the seawall in that you could build a pool. So you're saying 15 feet?
Correct. Abutting water is 15 feet. Internal lots that don't abut water, it is a 10-foot setback for accessory structures.
All right. So then he would only have no land behind his house, per se, after he put that in there. Or he would have at least...
He would have about 10 feet.
Right.
Based on this, it would be 10 feet from the outer face of the seawall.
All right. And so I would just be in favor of him putting in the pool. Thank you.
Thank you for your input. Anyone else? Anyone else? All right, then, I'll entertain a motion to close the public input.
Request public input be closed.
Second.
All right, we have a motion seconded to close the public input. Any discussion? All right, all those in favor? Aye?
Aye.
Anybody opposed? All right, public input is closed. It's on.
Can't hear you very well.
Yeah, no, it's on. Yeah. I will try and speak louder.
You're the only one.
I have mine in too, and I'm having trouble sometimes hearing. All right, how's that? Is that better? Okay. All right. Does the applicant want to come back up and respond to any of the witnesses? No. Okay. All right, then we'll turn it over to staff again.
Thank you, Sean Cullinan. Again, as I stated previously, you may find that this is consistent with the comprehensive plan and land development regulations. If you do, we are proposing 4 proposed conditions. Number 1, the variance as approved by the Board of Zoning Appeals is to reduce the required 15-foot rear yard setback by 5 feet to allow a 10-foot rear yard setback to allow a new swimming pool deck, and pool cage. This setback shall be measured from the outside cap of the seawall. Number 2, the variance shall only apply to the proposed swimming pool, pool deck, and pool cage as shown in the documents submitted. Number 3, this variance is granted for a term of 5 years from the date of approval from the Board of Zoning Appeals. However, the variance shall not expire if the owner commences the proposed development on or before the variance's term expires. And number 4, if the swimming pool, pool deck, or pool cage is removed or replaced, this variance shall expire, and all future development must be constructed according to all applicable codes in existence at that time, unless a new variance is granted specific to the development proposed at that time. This condition shall not apply to removal or replacement caused by a natural disaster or involuntary destruction of the swimming pool, pool deck, or pool cage. Thank you.
Okay. Any questions on the recommendations? Okay. Entertain a motion one way or the other.
Okay, I move that variance 22-005 be approved based on the Community Development Department staff report, June 1st, 2021. The evidence presented at the hearing and finding that the applicant has met the required criteria for the granting of the variance is listed in recommendations 1 through 4.
Do we have a second?
Second.
All right, so we have a motion that's been seconded to approve it with the 4 recommendations as outlined in staff report. Any discussion on the motion? Any further discussion?
No.
All right, hearing none, we'll move the question. All those in favor of approving this variance signify by saying aye.
Aye.
Anyone opposed? All right, the ayes have it. Variance is adopted.
Potty break.
Yeah. All right, you have your variance. Before we proceed to the next one, we'll recess for a few minutes. Right now, it's about 3 past. We'll reconvene at 10 past, 6 or 7 minutes, okay? Just to be able to stretch and take a little break. Okay, we'll reconvene the meeting. Next on the agenda is a petition, special exception 22-010. We begin by the presentation by staff.
Thank you. Sean Cullinan, Planning and Zoning Official. I have been sworn. SE 22-010 is for 21090 Iliad Avenue in Port Charlotte. Ms. Jerry Waxler, agent for Tillman Infrastructure, LLC, is requesting a special exception to allow a 125-foot tall communications tower facility consisting of a 125-foot tall monopole tower and a 5-foot tall lightning rod, as well as a 60-foot by 60-foot for 3,600 square feet equipment compound in the residential single-family zoning district. Subject property is located at 21090 Iliad in Port Charlotte. The attached zoning map shows the zoning of the subject property, which is residential single-family 3.5, and the zoning of the surrounding area. This is the 1,000-foot buffer map, the location map. As you can see, this is all single-family zoning. The attached area image shows the location of the subject property, which consists of approximately 3 acres and is located on the north side of Iliad Avenue to the west of Yorkshire Street and to the south of Peachland Boulevard. The attached site image is the 2021 aerial photograph showing a close-up view of the subject property and the adjacent parcels. Section 396.2 of the County Code establishes the regulations for the application review and decision-making process for special exception uses. The intent and purpose of special exceptions is stated in subsection 396.2a. This section of code also establishes the application process, public noticing requirements, and the actions that need to be taken by the applicant, county staff, and the Board of Zoning Appeals. In addition to the standard approval criteria for the developments and uses permitted by county code, a special exception use shall be granted only if all of the 3 approval criteria listed in subsection I are satisfied. The proposed use may be allowed as a special exception, provided the applicant complies with all development standards as well as any conditions imposed by the Board of Zoning Appeals to protect the interests of the public health, safety, and general welfare and prevent or minimize adverse effects on other property in the surrounding neighborhood. Section 3933 of the county's land development regulations establishes the regulations for the residential single-family 3.5 zoning district, and the applicant is proposing to construct a 125-foot tall communications tower. Section F13 allows for telecommunications facilities greater than 50 feet in height if approved as a special exception by the Board of Zoning Appeals. The proposed use may be allowed as a special exception provided the applicant complies with all development standards as well as any conditions imposed by the board. The applicant has provided the attached narrative, which describes what the applicant is proposing to do and addresses the 3 approval criteria for the special exceptions. As stated in the narrative, the applicant would like to construct the 125-foot tall monopole communications tower and the additional 60 by 60 3,600 square foot equipment compound. This area is to be fenced and will not have any on-site employees other than occasional visits by maintenance technicians. Section 3968 establishes requirements specifically for communications towers. The applicant has provided the additional application requirements found in Section 3968. Letters to wireless carriers, correspondence from the U.S. Fish and Wildlife Service, and a letter of intent and engineering report from T-Mobile expressing their need for another antenna in the area of the proposed tower, specifically to accommodate the new 5G equipment. The applicant has also provided 2 maps showing the existing coverage and proposed coverage for the surrounding area. A determination of no hazard to air navigation letter from the Federal Aviation Administration has not been provided as the proposed tower is under 200 feet in height, and Section 3968 only requires that if it's over 200. The applicant has also provided the attached existing towers map, which shows the location of the proposed tower in relation to existing communications towers. As noted by the applicant, there are no towers within a 2-mile radius that are capable of accommodating 5G equipment. The existing towers map also identifies the existing towers map also identifies 2 other towers located approximately 3.71 miles to the north and 4.54 miles to the northwest of the proposed tower site. However, these towers are located in Sarasota County and are outside of the coverage area of the proposed tower. As shown on the existing tower map, there is a tower located approximately 0.44 miles to the south. This tower, which is approximately 110 feet tall, was approved under SE 9721 in 2008. It was a major modification. One of the conditions of approval, as noted in the attached decision letter, states that the tower must be a stealth monopole tower and prohibits the use of exterior mounted antenna. The proposed communication tower is designed to have exterior mounted antenna, which is a technical requirement for 5G equipment as detailed in the attached narrative and engineering report. 5G and 4G services have different equipment specifications. 5G equipment is susceptible to overheating in enclosed monopole towers, which have traditionally been used for 4G communications towers. 5G transmitters and receivers are physically part of the antenna for some 5G antenna, and most of these will not fit inside existing monopole towers. Some towers can be retrofitted to accommodate 5G equipment. However, no existing towers within the service area exist that are of sufficient height or that can be upgraded to meet the needs of the applicant. The applicant has also provided the attached survey, concept site plan, aerial site plan, compound plan, tower elevation, fence details, and concept landscape plans. The concept plan and aerial site plan show the proposed location of the 3,600 square foot equipment compound in relation to the 3-acre site. The applicant is proposing to locate the communications tower and equipment compound in the southwest corner of the site, as shown on the aerial site plan. The closest single-family homes in proximity to the proposed tower are located approximately 148 feet to the south, 181 feet to the west, 346 feet to the north, and 506 feet to the east of the proposed tower. Section 39100 establishes the buffer requirements for developments in Charlotte County based on zoning and land uses, where communication towers require type D buffer when located in the RSF 3.5 zoning district. As shown on the attached concept landscape plan, the tower will be enclosed in the 60-foot by 60-foot equipment compound, which is to be fenced with an 8-foot tall opaque fence and a type D landscape buffer. The Community Development Department's environmental specialist has performed a cursory review, and their comments are in the attached memorandum. Part 3, findings. The 3 standards for approval of a special exception according to Section 396.2I of the Charlotte County Zoning Code are as follows. 1. The proposed special exception is consistent with the comprehensive plan. Finding, the subject property is located in the urban service area, and the proposed use of a 125-foot tall communications tower is a use that falls under the general range of uses for properties with a future land use map designation of low-density residential in the land use guide found in Appendix 1 of the future land use element of the Charlotte 2050 Comprehensive Plan. Comprehensive Plan's land use guide for low-density residential uses includes single-family residential, multifamily residential, manufactured residential dwelling units, recreational vehicle parks, sub-neighborhood commercial uses, recreational facilities in association with residential development, schools, and public services and facilities. As noted, communications towers exceeding 50 feet in height are only allowed as a special exception use in the RSF zoning district. This proposed use could be considered consistent with the general range of uses for properties with a flume designation of low-density residential, as communication towers are a public service facility and necessary utility which serves the surrounding neighborhoods. The proposed special exception is compatible with existing and permitted uses surrounding the land on which proposed special exception would exist. Finding, the subject property is located on the north side of Iliad Avenue, to the south of Peachland Boulevard, north of Casada, and to the west of Yorkshire Street, and to the east of Conover Street. The surrounding properties consist primarily of single-family residences. Subject property is approximately 3 acres in size, and the proposed tower and equipment compound are to be located in the southwest corner of the site, in a 60-foot by 60-foot area shown on the concept plan. This 3,600 square foot area will be surrounded by an 8-foot tall opaque fence and a 10-foot wide type D buffer as shown on the attached concept landscape plan. Staff notes that the landscape plan provided will require alterations to meet the requirements of Section 39100, but will be addressed during permitting should the requested special exception be approved. As previously noted, the surrounding area is largely built out with single-family residences. Communication towers are necessary to serve the surrounding residential community, and wireless communications facilities are essential to all land uses, including residential areas, and therefore need to be located within or near a residential, commercial, or industrial area of the county to provide adequate levels of service. As such, the county's land development regulations require that communications towers over 50 feet in height obtain a special exception and that they be developed in accordance with all applicable code regulations, including landscaping, to make the use more compatible with the surrounding land uses. Additionally, the applicant has provided a set of photo simulations. This series of photographs examines a potential view from 4 different vantage points in the surrounding area to assess the visibility of the tower from each location. The proposed tower, as shown in the photo simulations, is visible to varying degrees at all 4 surveyed locations. Because communication towers are a necessary utility and as conditioned, it is staff's professional opinion that the proposed special exception use could be considered compatible with the existing and permitted uses surrounding the property. Number 3, the establishment, maintenance, or operation of the proposed use shall not be detrimental to or endanger the public health, safety, or general welfare. Finding, staff is not aware of any evidence that would indicate that the establishment, maintenance, or operation of the proposed communications tower and equipment compound at the proposed location would be detrimental to or endanger the public health, safety, or general welfare of the surrounding properties. As required in Section 3968, the proposed monopole is constructed with breakpoint design technology, which means that in the event of a failure, the tower will collapse within the site. This is required for any tower which is not set back from the lot lines a distance equal to the height of the tower. Per Section 3968 D2A, the minimum setback distance shall be equal to 110% of the distance from the top of the tower to the breakpoint level of the tower. As shown on the attached concept plan, the proposed tower has a 180.5 foot setback from the north property line, a 93.6 foot setback from the west property line, 70.8 foot setback from the south property line, and a 426.4 foot setback from the east property line. The aerial site plan shows a 30-foot fall zone within the proposed tower compound, which in the unlikely event of a structural failure, the tower would collapse in on itself and stay within the 30-foot fall zone within the subject property. As previously referenced, Section 3968 requires the applicant to send correspondence to all entities owning or using non-exempt communications towers to inquire whether said entities have co-location abilities. The applicant received 1 response from SBA Communications Corporation stating they have space available for co-location of antenna on their existing tower facility located at 1365 Vizcaya Drive. That tower was approved under SE 9721 and allowed a stealth monopole tower, but prohibited the use of exterior antenna. While this tower may have space to accommodate the 5G equipment, a modification to the special exception would be required to allow the exterior antenna equipment necessary for 5G service. As of the report date, staff has not received any requests to modify SE 9721. Because this modification would be required and because no other towers of sufficient height exist in the area, there are no available co-location opportunities in the area. As conditioned, it is staff's professional opinion that the proposed communication tower and equipment are unlikely to be detrimental to or endanger the public health, safety, and general welfare. That is a report. Should we move forward, we have our recommendations with 6 proposed conditions. I'd be happy to answer any questions, and the applicant is also here for questions.
Thank you, Sean. Does anyone have any questions of staff?
I do. Just as you were ending your summary, you said that there was an existing tower that could accommodate 5G technology. To your knowledge, do you know if that tower is engineered to hold the new 5G equipment?
So that tower is a one reference in SE 9721. I believe there's a representative here from that SBA. That tower, the special exception required a stealth monopole, and the height is currently limited. There are provisions in code where they can increase the height, but in order to have externally mounted antenna, they would have to come back before you for a modification, where you'll probably have a room full of other residents for that application. So that is, in staff's professional opinion, the proposal meets the criteria as required, and be happy to answer any more questions.
So the short answer is no?
That depends on who you ask, sir.
Any other questions of staff? All right, thank you, Sean. At this point, we can have the applicant or the representative come up and make their presentation.
Before I begin my presentation, I'd like to call up Patrick Keene. I'm going to, if you could please come provide these to the clerk, to the members of the board, as well as to the court reporter and to...
Okay, and let me just, I was remiss. I want to let everyone know, and the applicant is aware, that Mr. Vieira has to leave in about 20 minutes. But we will have a quorum. We can constitute a quorum with 3. All right?
Thank you. Anyway, I'd like to call up Patrick Keene just to briefly present his qualifications, get him qualified as an expert, and then he will actually come up later in my presentation.
Sure.
Mr. Keene?
Good morning, Patrick Keene, 1368 Northwest 86th Way, Coral Springs. I have been sworn in. I work as a radio frequency engineer for T-Mobile. I'm the person that prepared the RF radio frequency report for the application. My background includes more than 25 years of design and planning of cell phone networks since 1996. After having received a Bachelor of Science in Electrical Engineering, partially on the GI Bill, I'd served in the Navy for 6 years as a radar technician. Part of the responsibilities as an employee of T-Mobile as an engineer, and my colleagues and I identify areas that have deficiencies or coverage problems and then propose solutions. And that's why we're here today, is we have a need and we have a solution.
At this time, I would like to proffer Mr. Keene as an expert witness for this hearing. My name is Jerry Waxler. I am a land use attorney with the McCrory Law Firm, here today representing Tillman Infrastructure, LLC. I have been sworn. I have been practicing land use law for over 30 years. In the course of that 30 years, I have also drafted land use and zoning regulations for multiple jurisdictions, and I have taught land use and zoning for courses for which are being offered both general continuing education credits for engineers and consultants, as well as for lawyers. Tillman Infrastructure is requesting a special exception for a 125-foot monopole communications tower with an overall height of 130 feet, including the lightning rod, in the RSF 3.5 zoning district. I request that Tillman's application for special exception, with all included documents, plans, and studies, be submitted into the record of this hearing. And I have one question of staff. Sean, will you confirm that the application was complete when it was submitted and is in compliance with the requirements of the Charlotte County Code?
Yes, it is.
Thank you. There are 3 general approval criteria which must be considered by this board. First, that the requested special exception is consistent with the comprehensive plan. As noted in the staff report and Tillman's application, the property is within the urban service area and is designated as low-density residential on the flume. The low-density residential flume designation expressly includes public services and facilities as a permitted use in the low-density residential designation. Cell phone service is a necessary and common public service, and communications towers are necessary to provide that service. As such, the requested special exception is consistent with Charlotte County's comprehensive plan. Second, the requested special exception is compatible with existing and permitted uses surrounding the land on which the proposed special exception would exist. The communications tower is supposed to be placed on land owned and developed with an existing church. All the land surrounding the church is developed with single-family homes. The term compatible is a specific term of art in Charlotte County. It is defined in the Charlotte County Code of Ordinances as, quote, capable of orderly and efficient integration with other land uses and zoning districts, end quote. Compatibility does not require that the use be the same or that it does not create any impacts. It requires only that the use can be integrated into its surroundings in a manner that is orderly and efficient. The proposed location of the tower places it 345 feet to the nearest home on the north, 140 feet to the nearest home on the south, 507 feet to the east, and 150 feet to the nearest home to the west. This is a low-intensity use consisting of the monopole tower, the antennas at the top of the tower, and an equipment compound at the base of the pole, which will include an emergency generator. The tower will not generate noise. It creates no ongoing traffic. Service trucks will drive to the site intermittently. Traffic is much less than the traffic generated by single-family homes. There is no light required because of the height. There is no light required at the top of the tower. The tower and the compound are proposed to be placed in the middle of a stand of mature oak and pine trees. The compound will be fenced and surrounded by a Type D buffer, the most intense buffer. Together, the existing trees, the landscape buffer, and the fence will minimize visual impacts from the ground. If you look up, will you see the tower? Of course. Does that prevent the tower from orderly and efficient integration into the neighborhood? It does not. The best evidence of that is to look at houses close to another tower located within the service area, the SBA tower that was referred to. And if you can go to the next page, please, Sean. The tower, you can actually see the shadow from it. It's almost right in the middle of that church parcel. This tower is a 90-foot tower providing 4G service. The antennae are located inside the tower. Like Tillman's proposed tower, it's located on church property, tucked within a stand of trees. The closest house located, and that is the arrow that is running horizontally, that sold in May 2018, well before the current run-up in prices, for $345,000. That tower was in place at the time that house sold. The house does sit on 5 lots, and it is large but not huge, 2,500 square foot of living space. Right after closing on the home, the new owner then purchased lots 18 and 19 for an additional $14,000, bringing his total investment to $359,000 for a house located approximately 285 feet from a communications tower. The 1,100 square foot house, built in 1971, and you can see that as the arrow that is going vertically, located on lots 20 and 21, sold in 2014 for $85,000 and in 2020 for $179,000. If cell towers were incompatible with single-family residential use, you'd think that would be reflected in the values of the surrounding homes, but clearly, the values of the surrounding homes are in line, or in some cases, as with the closest house, in excess of what you would expect to find in the neighborhood. Tillman's proposed tower will be concealed at ground level, will produce minimal traffic, no noise, no light, and will not affect property values if this is evidence of how properties are affected by cell phone towers immediately adjacent. The proposed tower is compatible with the surrounding uses, a conclusion also reached by staff. 3, the established maintenance or operation of the proposed use shall not be detrimental to or endanger the public health, safety, or general welfare. As previously stated, this is a low-intensity use which will generate minimal traffic, noise, and light impacts. Additionally, the monopole will be designed for wind speeds of 149 miles per hour. In the unlikely event of a structural failure, the fall radius of the tower would be within the 60 by 60 leased area and posed no threat to surrounding homes or to the church. Our application includes a letter from Sabre Industries, which will design and supply the monopole, which further describes the structural design and the fall radius. Additionally, I do have a structural engineer with me from Tillman, so if you have any specific questions about the fall radius and how these are designed, we can call him up and he can answer those questions. We concur with staff's conclusion that the proposed tower is unlikely to endanger the public health, safety, or welfare. In addition to the general criteria, communications towers are required to co-locate with existing facilities or demonstrate that existing facilities meet one of a list of 6 criteria that would prevent co-location. The proposed tower will house 5G equipment for T-Mobile, designed to serve a 10-square-mile area of Port Charlotte, currently showing poor signal levels, as reflected in the RF report that was submitted as part of this application and which was prepared by Mr. Keene. There is one tower located within T-Mobile's search area, but that tower meets 4 of the factors that prevent co-location. It is not of sufficient height. It does not have sufficient structural strength to support the 5G equipment. It does not have sufficient space for the equipment. And 4, there are other limiting factors that render the existing tower unsuitable. Evidence of this was actually provided by the tower owner itself, SBA, which submitted a letter indicating its intent to apply for a modification to its special exception. That special exception would increase the height of the existing tower from 90 to 110 feet. So the existing tower does not have sufficient height as it stands today. The existing tower's special exception prohibits antennas to be placed on the exterior of the pole, and 5G equipment does not fit in the interior of the pole. So the existing tower does not have sufficient space for co-location as we stand before you today. T-Mobile has not upgraded the equipment on the SBA tower since 2016 due to size limitations. According to the letter, the existing spine and canisters will have to be replaced, so the tower does not have sufficient structural strength to support the 5G equipment. Most importantly, even if modified, the existing tower will provide inferior coverage, which will ultimately require additional towers as opposed to reducing the proliferation of towers. At this point, I'd like to bring up Patrick Keene, a radio frequency engineer with T-Mobile, you introduced him earlier, to further discuss the deficiencies of the existing tower, as well as his study and his conclusions.
Good morning, Patrick Keene. I'm here to speak a little bit about our need for a new tower in the area and the reasons why. First of all, there's about a 10 square mile area that has poor or no 5G service in this part of Port Charlotte. It's sort of bordered on the north by Veterans Boulevard and on the south by Tamiami Trail. And if it's about 3 miles, the center of that 10 square mile deficiency is about three miles east of the intersection of Veterans and Tamiami. It's very close to the existing tower, that the SBA tower that we have 4G antennas on. The reason we're here today is because we cannot, as it stands, we cannot upgrade that existing tower with 5G equipment due to the size and the operational constraints of 5G equipment. The antennas are much bigger. What we call the radios, the transceivers, they're larger, and they just don't fit inside of these unipole towers for the most part. So, like I said, we have existing 4G service in the area, and our antennas are at 97 feet. But as was mentioned, we haven't been able to upgrade those antennas or anything on the tower top because of the size constraints since 2016. So we're like 3 technology advances behind in this area. And because of that, even the 4G footprint is not robust enough for us to provide adequate service in some areas. Within that 10 square mile area where we have poor or no 5G service, there are pockets of 4G where people would have difficulty using their phone. They may have to go outside to use their phone at their home. They may need to stand next to a window. They may experience problems with drop calls, and there could be problems with the E911. It's rare, but sometimes a person's in a poor service area and they can't dial E911. So that's a very important consideration for us. In terms of the 5G deployment, we have T-Mobile's dedicated to deploy 5G nationwide, and we have obligations with the U.S. government. We have, all the companies, AT&T, Verizon, T-Mobile, we lease the spectrum from the government, and there's requirements that we have to be able to provide that service that we lease the spectrum for to a certain amount of the population in a certain time frame. And if we don't do that, we get penalized. And then from an engineering standpoint, we just want to make the network better. 5G is expected to bring a number of capabilities that we don't experience now, primarily capacity. There are so many different types of cell phones and devices and people using them for so many different reasons that the networks are over capacity. They can't handle the cell phone traffic, as we call it. And so 5G is adding, sort of like on a highway, adding more lanes. The other thing about the 5G systems is that it's actually going to improve the capacity for a couple of different reasons. One of them is that the antennas are going to be more directive. Right now, the antennas for 4G and below sort of just broadcast in a general direction. The 5G has what's called beamforming, where they can pinpoint specific areas, and that actually makes the cell phone use less power because the cell phone has a dedicated beam, a signal, and so it doesn't have to compete with the other cell phones to try and raise the power. That's what happens when you have a lot of people using cell phones. The cell phones have to keep raising their power because the other cell phones are competing against it, so to speak, to reach the tower. So 5G promises that the power levels at your phone on paper are going to actually be lower than the 4G. So just a quick summary, we do have a need to provide 5G service in the area. We've upgraded all the surrounding towers. So there was a map included with the radio frequency report showing about 7 towers that surround our proposed area. They've all been upgraded to the maximum capacity with 5G equipment, 4G equipment as applicable or as possible. And though we have seen improvements, it's not enough for us to meet our requirements. There are no other viable towers to install 5G equipment on right now, including the one we have 4G equipment on now. We can't, it won't work as it stands. And the tower that we're proposing here will provide mitigate the service deficiencies we have in that area by providing a robust coverage footprint, as we call it, for the community. And just a quick note that T-Mobile follows all the FCC guidelines in terms of emissions, well below anything that of concern. So if there's any, I'm here to answer any questions or address any concerns, and I think that's it. Is there anything else?
But John, Joe.
Thank you, Patrick.
I had a question.
If I finish my presentation, I will bring him up, and then you can ask all the questions that you have, if that's acceptable. Thank you, Mr. Donor. In evaluating a request for a special exception, you must consider only the circumstances that exist today. There is no pending special exception for modifications to an existing tower within the search area. We do not know if the existing tower can be modified to structurally support the 5G equipment. We do not know if an application for special exception to modify the existing tower will meet the criteria to be approved. What we do know is that as I stand here before you today, there is no tower within the search area that can accommodate co-location of 5G antennas and cooling equipment. It cannot even, the tower that exists today, accommodate upgrades to the existing 4G equipment, and therefore you have a deficiency not just in 5G service, but in 4G service in the area as well. Everybody wants good cell service, but nobody wants a cell tower in their neighborhood. I understand that. I and you also understand that if the criteria for approving a special exception for a communication tower was whether the neighbors approved of the location, we would have no cell service in Charlotte County. The criteria for approval are very specific. Tillman's application, its testimony presented today, and I would ask that the PowerPoint presentation also be submitted into the record, and the testimony presented today by the expert planners from community development as well as by our expert radio frequency engineer all provide evidence that the criteria for approving a special exception has been met. For that reason, Tillman Infrastructure LLC requests approval of its application for a special exception. Patrick Keene, Chris Fry, who is a structural engineer, and I are all available to answer any questions that you might have. Thank you. Mr. Donor, shall I bring Mr. Keene back up?
I have a question for the engineer.
Yes, please.
5G is generally a lower power system, right, than 4G and 3G. So if what I'm getting at is, if you locate a tower, you're obviously doing it to optimize the coverage for some small area. If you had to move that tower, say 1,000 feet, it would probably considerably affect that optimum, correct?
Depending on the area. Downtown Miami, absolutely. Here, moving 1,000 feet would affect the footprint because you're sort of shifting. It's like as if you have a spotlight and you can kind of move the spotlight around. Mm-hmm. So you'd be shifting that whole footprint 1,000 feet. And it depends. Does it matter? Maybe the 1,000 feet that you're going to miss is a swamp, right? So that wouldn't matter. But this is all residential, so moving 1,000 feet will affect the coverage radius a little bit. But due to the increase in our elevation and the new technologies, we expect to have a similar, actually a better coverage footprint than existing.
Okay. So when you pick this particular location for a tower, it's because in terms of land available, that's the best place you could site it.
In this case, yes. Usually what we do is we draw a circle on a map, and then a land specialist will go out and try and find a location for us.
Okay, thank you.
Thank you, sir.
Any other questions? So a note for the record that Mr. Vieira is leaving at 10:45. Any other questions?
Not from me.
Okay, it's time for the public comments. Please come up with one at a time. Again, sign in, state your name, and
Morning.
and let us know. Good morning. Let us know what you've been sworn.
While they're being sworn in, if you would like to, I believe you said at the beginning, but there's the time limit of 3 minutes for public comment. Also, prior to the meeting, I handed out 2 packets of documents labeled Exhibits V as in Victor and W as in Walter. That is correspondence as well as a petition from the neighboring resident, so I just want to make sure that you are well aware of that.
Okay, thank you. Good morning.
Good morning. For the record, my name is Melissa Murrin. I have been sworn in. I am an attorney with the law firm Jimerson Burr, and I'm here today representing SBA Towers 2, LLC, who owns and operates the nearby tower that we heard about. It is located 0.4178 miles from the proposed tower. My office sent in SBA's opposition last week, but I wanted to provide another copy to have it on the record. Thank you. As stated in the application, the new tower is being sought by T-Mobile to deploy 5G equipment. T-Mobile is currently a tenant on SBA's tower that's nearby. As explained in our opposition and the staff report, the SBA tower cannot at this time deploy 5G equipment because when the tower was approved to be constructed, it was approved on the condition that all antennae have to be internal inside the tower. To accommodate 5G equipment, antenna has to be placed externally on the outside of the tower. However, as stated in the sworn affidavit testimony of Brooke Irby with SBA, which is attached to the opposition as Exhibit B and submitted on the record, SBA's existing tower can be modified to accommodate 5G equipment. And SBA is currently in the works to gather all of the necessary documentation to submit its application to modify its tower and will be applying to modify its tower by the end of this month. Therefore, at this time, the applicant cannot meet the requirements under the code, which provides that, quote, the applicant must demonstrate that no existing telecommunication facility or alternative support structure within the applicant's geographic search area is reasonably available to support the applicant's facility. I will emphasize that it does not say that the applicant must demonstrate that there's no tower available. It has to demonstrate that there's no tower that's reasonably available. As the SBA tower, which again is located only 0.4178 miles from the proposed tower, is reasonably available, the applicant has not met its burden. Further, the code requires all applicants to send letters to all nearby tower owners to inquire whether there's room on the tower for co-location. SBA did respond to that letter and informed the applicant that there was room. It wasn't until May 13th, 2022 that SBA learned of T-Mobile's equipment configuration requirements. Since that time, SBA has set the plan in motion to have its tower modified to allow co-location of 5G equipment. Of course, the requirements to inquire about space on nearby towers for co-location is simply not to check a box. It is to work in good faith with nearby tower owners to achieve co-location without having to construct additional towers. Further, attached to my opposition are several RF charts. One more minute.
It's up to you, Mr. Chair.
As an advocate, is she allowed as much time as the applicant?
In this situation, she would not be eligible for additional time based on her status, but it's up to you, sir, whether you want to give her additional time. Our view is that when you're making a legal argument that's based on a challenge to the code provisions, that it's probably wise to give additional time.
How much time do you think more do you need?
30 seconds.
You may finish.
Thank you. Attached to the opposition, there are several RF charts which show that there is no gap in coverage between the proposed tower and the existing tower. Accordingly, SB submits respectfully that the application be denied or at a minimum deferred to prevent the construction of a new tower right next to an existing tower without any additional coverage or benefit to the citizens of Charlotte County. Thank you.
Thank you. All right, thank you. Anyone else like to comment? And I want to let everyone else know,
gave her the extra time because she's presenting evidence, not just her opinion, whether she wants it or not. All right, sir.
May I question the woman that just spoke and using the
Well, I
right
think
for
we do
cross-examination?
that after everyone's had a chance to speak. Is that right?
This is not rebuttal. I'm looking to question.
Hold on.
My view is that you should give the applicant's attorney the opportunity to ask questions of the witness at this point.
You say it's appropriate?
It's appropriate, yes,
Okay.
sir.
All right, certainly. Proceed.
You may recall the witness, Mr. Chair. Just for those who are in the audience, we would appreciate it if your comments would be saved for your time to come up here. And the reason is because there's a court reporter here attempting to transcribe this hearing, and she can only listen to one person at a time, no matter how many ears she has on her body.
You indicated in your testimony that you have an affidavit from Ms. Brooke Irby that 5G equipment can be located on the property. Ms. Irby is the site marketing manager for SBA Corporation, correct?
Correct.
Ms. Irby is not a structural engineer, is that correct?
No, but they did communicate with their internal engineering and did confirm that the tower can be modified to accommodate 5G equipment, T-Mobile's 5G equipment, and additional carriers' 5G equipment. So
And
that
T-Mobile
has
has not provided you specifications has not provided to SBA the specifications, so you are assuming the specifications that T-Mobile would require for this tower and for modification, correct?
It is my knowledge that on May 13th, 2022, T-Mobile provided equipment configuration requirements.
And finally, Ms. Irby is not here for me to be able to cross-examine her, and there is nobody from SBA here to be able to cross-examine. Is that correct?
Correct, but her affidavit is sworn testimony. It is not hearsay. It is sworn testimony that's submitted on the record.
Thank you.
Thank you.
Okay, we can proceed.
At this time, it would be appropriate to proceed with the comments, Mr. Chair.
All right, if anyone wants to come up, comment pro and con, again, sign in, state your name, and let us know whether you've been sworn or not.
I have not been sworn in.
Do you swear or affirm the testimony you're about to give is the truth? If so, answer I do.
I do. My name is Miko Arroyo. I live on 21064 Alpine Avenue, a resident of the neighborhood in question. And I just urge the board here to take in consideration some of the questions that have been raised just by presentation of the applicant. One is T-Mobile is the one directing this. Is there going to be other carriers that are going to be coming into our neighborhood and also asking requests for special exception to be able to put a tower in? Or is this going to handle everybody's 5G network? Two, the reasonable question of just compatibility of the existing towers. I don't know that we've had that opportunity to have that discussion on this board. There was a presentation of a special exception that was permitted or that was applied by the applicant. And to my knowledge, there's been no discussion about the existing SBA tower, which the other person brought up in here. So I think it's very valid for the board to take some time to really discuss if this is in the best interest of general welfare of the citizens of the community that's in question here that's going to be affected. And so the other thing is just, we talked, there was a presentation also in that application that was discussing property values. And we all know that, the property values have gone up. And I would say that cell phone towers do affect property values, but at this time, we're in a unique situation where the market has just gone crazy and supply and demand is really driving that, not whether or not you live next to a cell tower. When the market reduces again, you're going to see that there's more supply out there, and you're going to see that's going to affect the cell phone tower is going to affect property values, in my opinion. But we can't state that right now because I could sell my house for triple what I bought it, right now on Alpine Avenue, without any major improvements on there. So, that it does affect property values. Every article that I've read, every instance of property values with self-fold towers, anything in there, it does affect our property values. So you need to take that into consideration also. And that's all I got to say. Thank you very much for your time.
Thank you for your input. Anyone else like to come up?
My name is Pierrette Breedy. I'm not a public speaker, so I shall be reading my statement. I am strongly against an exception to our RSF 3.5 zoning district. A change as this should not be of substantial detriment to any adjacent property or to the public good and the character of this district, and should not be harmed by the granting of this exception. The existence of this tower will be primarily financially gained for one landowner, which will not in any manner outweigh the significant damage made to the public good in the form of housing, desirability, and declining property values. In this neighborhood, there are many older fixed-income residents. Declining property values may well have a significant adverse effect on their financial and health conditions. For most people, their home is their 401k retirement. In closing, the construction of a 125-foot communication tower, visually 12-story building. Would you like to look at it? It's not to be put in a residential area. There are plenty of commercial, industrial zoned lots in this county to build a structure of this size. Thank you.
Thank you for your input. Anyone else? So you have your hand raised. Why don't you come up next? The man, you can go after him.
Wayne Ballou, 21017 Denise Avenue, and I have been sworn.
Okay.
Just one contradictory. There was a study done just last year by the National Association of Realtors in conjunction to tower placement and residential values. Within 1,500 feet, they say it's 7.6%. Outside of that, it drops to 2.6 in just visual. How valid that study is, I do not know, but it's clearly out there for everyone to see. It was done in 2020, so that should clear up some of the other controversy of not harming values versus harming values. I certainly am against it, especially if there's another tower that's already there. What happens when we go to 6G or the next one there? Do we get another tower? You know, if we've already got a tower, which is within 2.5 feet, it works, modify the tower or rebuild the tower there. Simply just to place a tower for financial gain seems redundant. That's it. Thank you.
All right, thank you for your input. You can come up next.
Yes, my name is Colleen Hunter. I was sworn in. I'm at 1203 Yarmouth. I'm not a professional speaker. I'm going to wing it. I would like to say that my husband had a serious cardiac event 2 days ago, major injuries, and he's currently in the hospital, just about ready to have surgery, but we both agreed that it's very important for me to be here to state our concerns about what I consider to be a monster dystopian tower going into our neighborhood. I'm attending this meeting because I feel this will have long-term serious consequences to our health. My husband and I just purchased a home a year ago. We left an urban environment for our health and well-being. And we chose this residence in this neighborhood because it's very quiet, it's very charming, it's very simple. A lot of nature and animals. It has positively affected the quality of our life. And a tower like this has a dystopian appearance. It does not belong in a charming neighborhood. It belongs in an industrial wasteland. And there is plenty of commercial environments surrounding this neighborhood that could house one of these towers. There's no reason that it needs to be on top of cute, small, tiny little bungalows, maybe a couple of medium-sized homes mixed in. The vision of this tower will be huge. They talk about these cute little shrubbery, but the shrubbery will only maybe cover up, what, 15 feet? This is a 125-foot tower. It will tower over, this massive tower over tiny bungalows. And I question the accuracy of the experts when they say that there isn't going to be lights. I can't imagine a 125-foot tower not having a blinking light. I am also very upset. I don't have time for a doctor's documentation to document my medical health issues that can be affected by this. This will negatively impact my medical conditions. I'm extremely sensitive to loud noise. I question the accuracy of this woman. The lights, blinking lights, will affect me. The airplanes in the area might be rerouted over my home because of this. I don't know. The questions haven't been answered in this regard. Not enough time.
So, ma'am, you are opposed, right? Because your 3 minutes are up. It's like,
I thought it was 3 to 5.
no, it's 3 minutes. We gave the attorney, because she was representing a client.
Okay. Well, this is.
No, but I have to adhere to that 3 limit.
Okay,
minutes.
that's fine.
Just so I'm clear, you are opposed to it.
Yes.
Okay. Thank you.
And
that's on the record. Hey, who'd like to come up next?
I don't need cell phone service. We have enough.
All right, thank you, ma'am.
Good morning. I live on the big property next to the church that takes maybe more than half a block, and I live on 1105 Yorkshire and the other side.
State your name.
Samar Jarrah. Samar Jarrah. Okay. And I have been sworn in. Everybody, especially the church, they park in my parking spots. I never call the police on them. They always have parties, and we allow them because they're our neighbors. Sometimes their kids jump off my fence, and I don't say anything because expect them to treat me the way I treat them. So for the church, really, after me living there for 33 years, to do such a project without having the courtesy to knock on my door and ask for my opinion, especially I am the closest to their property and to this project, I find it very unneighborly and unchurch-like behavior, honestly. But my husband is a cardiovascular thoracic surgeon. It's very important for us to have phones, and the phones are not really that great, the cell phone. But we have landlines, and he has been operating and going to emergency calls because we have a landline. And I have 2 landlines to overcome the problem and the excuses of no net. So if he's a cardiovascular thoracic surgeon who has to report to the hospital ASAP, and he has been surviving for 33 years in that property, then what's the point of a new tower? Plus, the way this project was presented today, it made me feel as if I am doing a service to humanity. T-Mobile is a for-profit company. It's 60% is owned by Germany, by the way. So that you make it, the lawyer presented it as if it's a government thing or a county thing, the way the county comes and does a swale. They knock on my door, they tell me we're gonna replace your grass, we're gonna put new one, but we have to do it. So I accept, and I don't fight it. But with a for-profit company doing that, I'm gonna fight it. And I'm not gonna really sit quiet and have my vision on. We passed through Hurricane Charlie. There wasn't any structure that was not destroyed by the hurricane. So I don't know what kind of engineering they are talking about where this is not gonna jeopardize my life. So I'm very, very sorry, really, that our neighbor who uses all my property to park their cars when they have Christmas parties did not even bother to knock on my door. I find it very, very disrespectful. Thank you.
Thank you. For sensitive or fair and balanced, is there anybody here that wants to come up who's for this? Give them that opportunity. Just don't want to hear a string and not give somebody else the opportunity who may be for this. Okay. All right. Who's next?
I was waiting to see if anybody wanted to be for it. My name is Nancy Hendrick again. I live on Dorchester Street, 1109 Dorchester Street. And the reason why most of us are here is because of the arguments that you hear from everyone. You know, everybody can do kind of research on the internet and find out all the things that people are saying. And the big piece is that I wasn't sure about health reason, radio frequencies, and things like that. And I know that you can't find anything on the internet, and they say everything is just fine with 5G. But again, there's no answers, there are no definite answers on that, because again, it's all new. Just like everything else, you gotta have people to figure out and then do studies on it. So we really don't know about that part. The other part is that the tower itself. If you go down 41, you can see on 41, and I think it's Harbor over there, is that the big cell tower. As you can see it, you know, in the pictures that, I'm sorry, I don't remember his name over there, is to show the pictures of the tower itself. The tower itself is really tall. It's got these little boxes on the side and everything, and it's pretty monstrous per se. And again, for these people that live right next to it and everything, they're gonna look at it, eyesore on there. And the other thing is that with the FCC and everything, if you want to get a radio, I was thinking about getting a radio station for my house and broadcast, but you can't do that. Okay, so the FCC has other answers that they have to answer for that, because it is the towers, FCC, and it has to be on a non-public kind of an organization. Okay, so they targeted churches. That's what they're doing, is targeted churches. If you go down Randolph Street off of there, off of Quesada and Randolph, the other church, I don't know if that's the modification, what the lady was saying, is that church there has a tower, but I don't know if that's the argument church that they're talking about or not. Okay, they got a tower, but there's no tower on top. to modify. And I saw that within, if you Google FCC towers, 5G towers here in Port Charlotte, there's a zillion of them. I don't know if they're all been approved or not, but if you go on their website, they're all over. So to the argument of we have to have it here, we have to have it in our neighborhood, is something that they targeted because, one, that little church, as we all know, needs money. Needs money. It's a dying little church. I feel bad for them, and I get it. And again, on your first piece and everything, I got 30 seconds left, is we can't define people that make money, but we get that part. But again, we're all in there, and that it's unfair that they target that, because without the people's voices, so, you know, we can do anything, and big corporations like them can do it. I am a T-Mobile subscriber, and I get it, what she's saying. But again, I don't want it in my backyard, like she said also. And the other part is a property value as well. And we got things that he said, she said. But again, you know, we want our house, and we live there. Thank you.
Thank you for your input. Who'd like to come up next?
Hello.
Come on.
My name's Mary Ann Bizard, and I've been sworn in. I live on Denise Avenue, which is 1 block south of the church where the proposed tower is to go in. Sign in.
And if necessary, you can pull the mic down so we can
I'm
hear you
short.
better.
I live 1 block south of the church where this proposed tower is to be installed. The front of my home faces the church on Denise, so when the tower goes up, I'm going to have a direct view line to this tower 24 hours a day. My husband and I have lived in this neighborhood for about 7 years. It's a very peaceful, quiet neighborhood. People walk their dogs, kids ride their bicycles, people are out walking all the time. Faith Life Church has also been a part of our community for the entire time that we've lived there. They provide children activities. They have Sunday and services, Wednesday evening services. We also hold our community watch program at their church property. They've been a good partner with us for that. We've never had an issue with the church until now. My husband and myself, we feel like the only reason that this proposed tower is going onto the church property is for financial gain and for greed at the goodwill of the residents who live in this community. Each time I go out my front door to do my yard work, to get in my car, to get the mail, or whatever else I'm doing, I don't want to have a 125-foot tower staring me in the face every single day. I don't want to look up at night to see a tower when I'm looking for stars or the moon or whatever I'm doing outside. I don't want that in my face as well. I'm asking the zoning commission here and the board members to deny this request. We have done a petition. I know you've received that. I would say 90% of the neighborhood is against this. We don't want this in our residential community. It doesn't belong there. It's a residential single-family community, and this is not something that belongs where they want to put this. So I would like to ask the board to deny the request and also to consider how would you like this in your neighborhood and in your backyard. Thank you.
Thank you for your input. Anyone else?
I have not been sworn.
Do you swear or affirm the testimony you're about to give is the truth? If so, answer, I do.
I do. My name is Joe Tiseo. I'm here today in my individual capacity as a longtime citizen of Charlotte County. So in looking at the staff report, I wanted to focus on part 3, the findings. Specifically, I want to go over each and every element of those findings. The first one is that the proposed special exception is consistent with the comprehensive plan. The staff's finding is that the proposed use could be considered consistent with this general range of uses for the property with a flume designation of low-density residential. The key word there is could. I want to go on to item number 2. The proposed special exception is compatible with existing and permitted uses surrounding the land on which the proposed special exception would exist. It's in the staff's professional opinion that the proposed special exception use could be considered compatible with the existing permitted uses surrounding the land on which the proposed communications tower would exist, and I guess that's due to the landscaping element. And finally, the third part, the establishment, maintenance, or operation of the proposed use shall not be detrimental or endanger the public health, safety, or general welfare. And the staff's finding is, as conditioned, it is staff's professional opinion that the proposed communications tower and equipment compound are unlikely to be detrimental to or endanger the public health, safety, and general welfare. Again, subjective. So there's a reason that these matters come before you, because what matters today is your opinion. While you should definitely value and respect staff's opinion and their professional opinion, what counts today, again, is your opinion. And what you have today that staff didn't have when they formed their opinion is you got public input. You're able to hear testimony from all different sides. Well, apparently just one side today to deny, other than the applicant. But this gives you enough leeway to use your opinion, because it's only staff's opinion. It's very subjective, as I've already stated. I would also like to know, perhaps you can do this on cross or in your questioning, a lot of times when they build these towers, it appears like it's for a single use, but the towers are opened up to other vendors. They're a profit center. They typically sign a long-term lease with the landholder, construct the tower, put their fixture on it, and then open it up to other vendors, and they pay rent to be on the tower. So while you may have the impression this is a single-use tower, a few years down the road, if this is approved, you may have multiple antenna on that tower. So it may not appear like it does today. But again, I encourage you to use your opinion and take public testimony into account today. Thank you very much. Oh, and I respectfully request you deny. Thank you.
Thank you for your input.
My name's Joe Torres. I've been up the block on 1038 Conover Street for 23 years. Been walking past this church for just about a couple times a week for that long. We've never, ever had a problem with this church either. They have their functions, and it's a lovely thing. And it's kind of shameful to think that now we're in an era where churches have become a commercial thing to make money. They need to make money. And it's sad. It's sad. This church has been there. Nobody's ever knocked on our door to say, hey, would you like to donate to the church? To maybe do some due diligence to maybe get donations. So I don't know how they make their money. But I don't agree with every little non-profit place in Charlotte County, in anybody's neighborhood, all of a sudden open up to make profit. It doesn't make any sense. I work 12 hours a day from home, up the block from this church. My wife works from home. She's been doing it for years now also. I have a successful company on Boca Grande for 22 years. The only people that tell me that it's detrimental to us is the people who want it. The engineer who doesn't live in this town, where she lives, I have no clue. Maybe Fort Myers or somewhere else. She doesn't live around my corner. But I don't hear anybody in here going, I don't have cell phone service. I don't have cell phone. I don't hear anybody saying that. There's no need to have this tower. There's already one there that they suppose if they didn't even find out about whatever, well, there's already one there, just attach onto that. There's no need to build something more, to make more ugliness in a small residential community. You can look right there. There is not one bit of commercial sign. There's nothing there. There's nothing there. It is a quiet community. We have a great community. We have a neighborhood watch. There's people that walk past my house probably on a daily basis, about 50, 60 people with their dogs and their kids and their bikes. I just don't agree with it whatsoever. I completely oppose this whole thing. I oppose churches. They should all be ashamed. This is how they're going to make money. If they want to make money, go get members for your church. That's what they need to do. They need to get donations. They need to work a little bit harder on their end before they go collect, because nobody even knows how much money they make. I don't know what these companies make. And I do agree with you that it's everybody's right to do what they want, but this is a nonprofit church. Everybody can do it, but to start this kind of precedence, and I know it's already there where they're targeting churches because they need the money. But what makes it seem to what business is going to come up next that needs to put something there? And like everybody else has been saying, 7G, 8G, everybody's going to have towers on top of their houses. But right now here, we do not need another one of these. Thank you. Please oppose it.
All right, thank you for your input. Is there anyone else?
Paul Haber, and I have affirmed to the truth.
Have you been sworn in?
Yes, I've affirmed to the truth, which is affirm or swear in. Yes, sir. The facility is a 125-foot tower and would be on a residentially zoned property in a residentially zoned area. This area is not commercial, and it is not a city. It's a peaceful neighborhood with peaceful property owners who pay property taxes. The reason why we have residential codes is to protect the welfare of the property owners. Making exceptions to residential zoning code causes measurable impacts to the values of the surrounding properties, the visual aesthetics of the property surroundings, and the future impacts that may not be disclosed in the application. It is the right for the property owners who are within the 1,000-foot radius who were given notice of this hearing to object to the petition number SC-22-010. I object to the petition for the reasons mentioned previously. I say to the Zoning Appeals Board to rescind the Tillman Infrastructure LLC request appeal for special exception for the telecommunications facility greater than 50 feet in height in the RSF-3.5 zoning district, and to rescind the Tillman Infrastructure LLC request appeal for special exception or variance for front yard setback variance of 3 foot to allow a 22-foot setback instead of the required 25-foot setback. It is objectionable for the request of the special exception to be granted. The current residential zoning codes are relevant to the property 21090 Iliad Avenue, Port Charlotte, Florida, and property owner Faith Life Church Ministries, Inc., whose president is James R. Webb. I stand with those present today and those who aren't present and are absent who are in objection to petition number SC-22-010. We are not here to compromise. We are not here to make deals. We are saying rescind and do not grant the application, the request appeal for the special exemptions petition SC-22-010. Thank you.
Thank you for your input. Is there anyone else? Come on up.
I have not been sworn in. My name is, I'm sorry.
Right. Do you swear or affirm the testimony you're about to give is the truth? If so, answer I do.
I do. My name is Donna Gilda Madrid. I've been in this community and neighborhood for 30 years as a taxpayer and a voter. Again, as people have mentioned, we have not had an issue. I have 5G, not had an issue. It seems a little odd that Ms. Waxler would come up and speak on behalf of a prior issue with a lady and her fence and her property values. That's a fence. We're talking about a tower that we all have to deal with. We've never had an issue with the church, as we all stated. They've been great neighbors. As opposed to what's going on now, we're confused as to why this was done, except for the benefit of of a great amount of money. This is not their neighborhood. The pastor does not live in our neighborhood. He does not have to deal with any of the issues. If you're living in our neighborhood, you should have a say. We should have a say of what is going on in our own neighborhood in concern with our health, our noise, our environmental issues. We've all had health issues. We don't want to make believe that maybe there's an issue or not with our health. We don't know down long term what will be affecting us. Nobody wants this. This is our greatest investment. As I've stated, I've lived here for 30 years. When they brought up a property off of Viscay, that person had an option to buy that property knowing there was a tower there. We're not given that option. We're told, live in your neighborhood for X amount of years, and if we want, we can do what we feel like it for monetary reasons. We can put up whatever we want. That is not the way this county is structured, as far as I'm concerned. And I think it's a great in service not to consider the neighborhood that this church does not pay taxes. They are living there in our neighborhood, and we've been good neighbors, and they've been good neighbors up to this point. And to not consider our property values, our health, our environment, our peace of mind is just inconceivable to all of us. As you can see, we are all opposing this. The only person that wants this is the church, who is making money, and of course T-Mobile. I'm a T-Mobile member, customer. I don't have a problem with my 5G. And, if so, that's an option to go place it somewhere where it's not in the middle of a neighborhood. It will be sticking out and causing a lot of contention with all of us. It's just not a fair issue that we should have to come here and defend. Hopefully we will never have to address these issues again, because, the way things are looking, the church can do what they want. And, that's just not a consideration on our part.
All right, thank you. Thank you for your input.
I have not been sworn in, so.
Do you swear or affirm the testimony you're about to give is the truth? If so, answer I do.
Yes. My name is Walter Sharp. I live directly across the street from this in Lot 21. I've been here 22 years. I've got cancer. It does put out radiation. It's not commercial property. The church is selling us out. They don't care. They want to make money, and the church wants to make money at our expense. And I don't want to look at it. I'll sell a house. I strongly oppose it, and I resent the whole thing.
Right, thank you for your input.
I could say 50 other things, but I don't want to hold everybody else up. Thank you for listening to me. Sorry.
Hello, gentlemen. My name is Scotty O'Connell. I'm a resident. I live in this area. I've been in the business for 30 years. I have 4 pieces of property in this neighborhood. Actually, I'm on the other side of Denise, and I have the top. You can't see it because I'm on the, if Sean can move that a little bit, we can see it. I'm on the lot. I have 2 properties there, and I have the 2 properties around me. I see the tower at the other church that can be modified. Now I'm going to look out my back door, I'm going to see the tower that they want to put up. So what I'm getting at here is, I have 4 properties. I pay a lot of taxes. A lot of people pay taxes. We know that the church, we do what we can for them. We love the church. We have our neighborhood meetings there. Everything. They're good for us. But they're going to make money off of this on our backs. If I had the much time as she had to prepare for this case, which you already heard what she said about the tower that can be modified, being a contractor, I would think it'd be cheaper to modify one which already has a generator pad, has 2 more pads at the other church for generators. They can modify that church and we wouldn't have this problem. The doctor that just spoke, that's lived there for 30 years, I'm behind there. Holy cow! What would you say? She's been there longer than the church has been there. Let's just get it down to where, be right. They never came to us. We have our neighborhood watch meetings there. They never mentioned anything to us. The only thing they've ever mentioned to us, hey, somebody's illegally parking in our parking lot. Can you do something about it? They don't even have a parking lot to hold the people that they have in church. I put signs out on Sunday. They came out screaming at me because I put signs out about the tower. Nobody in their church didn't like that. They didn't know about it. Let's be fair. It's all about the money. Mrs. Webb said to us, they prayed, and they said, we need the money. Let's do it. Please. Please. There's more to this than just the money. If you can remodify that other tower, modify it. Thank you.
Thank you for your input. Anyone else? And I'd ask any I'd like to ask anyone who does want to speak, if you have something new to offer as well, all right, please do that up front before you run out of time.
Okay. I know I've only got a couple of minutes, so I'll try to be quick here. Regarding property values, I did a little research on the internet, and the possible effects of cell phone towers on property values is extensive. In general, proximity to a cell tower appears to have a negative effect on property values. The study from the University of South Alabama analyzed over 23,000 home sales in Mobile County, Alabama, relative to their proximity to the cell towers. The research found that homes within 0.72 kilometers, which is 2,362 feet, of a cell tower decreases in value an average of 2.65%. In addition to the cell tower was visible from the property, then the properties decreased on average of 9.78%. A similar study in Kentucky found properties within 1,000 feet of cell tower sold for 1.82% less than a similar property located 4,500 feet away. And then according to the National Association of Realtors, we found that homes close to towers sell for a discount of up to 7.6%, and that any noticeable effect disappears at 1,500 feet. On average, the potential external cost of a wireless tower is approximately $4,132 per residential property, which corresponds to a negative price effect of 2.65%. And regarding safety, what is a safe distance? In 1996, the federal government passed the Telecommunications Act of 1996, the first major overhaul of telecommunications law in almost 62 years. The goal was to allow more entities to enter the communications business, from long-distance telephone service to broadcast and internet services to cellular infrastructure. This act allowed for more competition. That same year, the FCC adopted safety limits for human exposure to wireless radiation in anticipation of the oncoming age of digital and mobile integration. That was 26 years ago. Today, now into our 5th generation, 5G of mobile content and data delivery, with phones and iPads instantly accessing the latest news, self-driving vehicles lining the roads, and AI infiltrating our consumer lives, the FCC has maintained its regulations based on scientific data and health standards from 1996. The only problem is that in 1996 there were 30,000 cell towers, or about 388,000 less than today. Each powers up and emits levels of radiation just outside your bedroom windows. The FCC recommends a maximum RF radiation exposure level to, guess I didn't talk fast enough.
Ma'am, could you state your name for the record, please?
Jane Merjeski. I live on Alpine Avenue.
Thank you very much.
All right, thank you for your input.
I've been sworn. I won't repeat what a lot of the people have said. I can only give you what I read that the FCC puts out. And they talk about safety and what is they're looking at today, and everybody seems to be looking at the minimum, or maybe it might hurt you. So what they say for electromagnetic radiation is, to start with, these type of towers do not need to be within 22 miles of each other. Not to argue with the lady that talked earlier. That's 22 miles, not 0.4 miles. The other one is, they talk about the distance that is considered safe. And you can tell it's a government because they do it in the metric system. And they talk about 300 metric yards, which basically means 1/4 of a mile is considered to be not a good zone for individuals to be in. They argue this point very simply by saying birds, bees, trees are harmed by this, and birds and bees die and tree tops burn. So if they're wrong, then I have no argument here about all of the other stuff. All I can say is this church group's 501c3 is in jeopardy. They're not following what they're supposed to be doing to maintain that. They have to have donations of a minimum of 1/3, and they have to have some sort of outreach program, of which I was unable to find any, or they were able to provide. So that's all I have to say. Thank you. But it's 22 miles.
Anyone else?
I'll make this short. When I heard about the towers potentially being constructed in the future, I went out and started walking to get signatures for the petition that oppose it. I'm here today for the people that couldn't make it. The 94-year-old lady that basically said, Mike, give them hell. I didn't have to. I commend everybody that came in here today. They did a great job. This doesn't need to be done. And it's really up to you guys to sort out what is the truth and do what's right for the people that live in our area. That's all I have to say. I thank you.
Sir, could you state your name for the record, please?
Mike Dan. Mike Dan.
Thank you very much.
Thank you. Anyone else?
For the record, my name is Joseph Durbin. I'm a member of the church. Pastor Rich couldn't be here today because of health issues, but I wasn't planning on speaking. I came only to listen to the needs and concerns of the community, which is what a church does. It's a local church. And as many people have already spoken, that we've never caused problems. We're there to help and serve the community. Our motto, our faith statement is love God, love people. So we have no malicious intent. We didn't search out T-Mobile. We didn't search out that we needed more money. What prompts me to speak is the image that's given about the local church as a money-grabbing business. We operate under free will offerings, and that goes right back into the community, which we happen to pay for many events that are given free to the community. Never have we charged once for any of the events that we have for the children of the community or for the other things that go on. We get the youth off the streets at night so they're not out running around. So I would like to make sure the record shows that we're not money-hungering corporation of some sort. We're there to serve, and this was a way that our board met when it was offered. It was agreed upon to submit it to the church members, and the church members okayed that, which happened to be also people that live in the local church. Not everybody, but that is the truth of the matter, and that's all I have to say about it.
Okay, thank you for your input. Morning.
Hi. My name is Liz O'Connell. I've been here 40 years. That takes me back all the way to where Publix is in Charlotte Harbor, was the movie theater. So that's how long I've been here. There's probably a few things in Charlotte County that I've noticed that I can say I really opposed to what they've done. 1, Murdoch Village. 2, Sunseekers. 3, backyard chickens. 4th, this is really bad. So I'm just glad she showed up on our behalf, and I think that you should give us the opportunity to let her modify the tower so we don't have to deal with this. So the church, we appreciate what he just said. If they really cared, they could done deal. We don't want it. We don't want to do that to our neighbors. So we have the chance to modify one. They're going to represent us. We didn't give that opportunity. We got our sheet of paper, what, May 20th? May 20th? We couldn't come up with what these guys came up with. Thank you. Thank all of you for who signed it. They went around just in that short time. So we couldn't even get our information together for you guys. So it's up to you. Commissioner Teseo, I believe that was him, and I believe he's appointed you for our district. So we'd appreciate if you would follow what he said. Make up your mind. Don't let this make your decision. Thank you.
Thanks. I'm here in opposition to the cell tower, all right? I was going to make suggestions about there's some areas close to us, like up on Veterans Highway. If you went actually into Northport, you have no houses at all on Yorkshire, not a one. I hate to see this happen in our neighborhood. It is a nice place to live, but we know that our valuations are going to be going down. That's gonna eat into the Charlotte County coffers. We have I'd certainly like to have you entertain the thought of going up to the tower on Viscaya, all right, and see if they can modify that. And I know she's already said that they can. And I'd like you to look into that. Thank you.
Thank you for your input. Anyone else before we move on?
I was already sworn in. I am not a public speaker, and I'm trying to control myself because this hurts me so much. We live on Congress 13. right behind the doctors. 13. I do a lot of gardening, and I love my neighborhood. We always watch our health. We didn't even buy 5G phones because we're trying to watch and not get too much of these waves. My kids go in the Lanai every day. I'm thinking, what do I have to do? It's just because you don't know the long-term effect of this. Because it's so new, that doesn't mean there isn't any long-term bad effects. It's easy for you to say you for it because you're getting paid to be here and you're getting money for the church to be there. But for me, I'm gonna live there. We bought that house because we wanted to live there forever. And now I'm wondering, do I have to plant trees now? Tall trees to keep that waves from going to my house? How can I sit in Lanai and I could see behind see that, as you can see, I live on 13 and we just have one house and then it's the church already. How can I sit on the Lanai and feel good and not worry about maybe getting a cancer? Okay? How can I garden? How can I even sleep? Is it better to sleep in this room so I don't get enough of these waves? What can we do with the roof to make sure that those waves don't go through the roof? I feel like we have to move because I can't have peace when that is built in there. And every time I drive to work, I'm only a CNA. I don't have much money or I don't have much education, but every time I pass by, I'm so angry at the church. I say, Pharisees, how dare you do this to our neighborhood? You want the money more than you love your neighbor. You still love people because you love God. I don't see how you could love the people and do this to our neighborhood. How dare you say you love us as you love God? How dare you? How could you? You don't even know the long-term effects of this thing. It's too new. I'm sorry, I just so overly emotional because I passionately don't want this in our neighborhood. I hate it. I'm worried for my husband, for my health, our pets, and the animals and the birds that I feed in the backyard. All the creatures that I'm feeding, and I see the children and the people walking in the neighborhood. They're walking because they want to be healthy. And how dare you put this there so that even the people trying to be healthy, they'll have to start worrying, what is the long-term effect of this thing doing in our neighborhood? So how dare you, Pastor Webb? How dare you? You're a Pharisees. That's how I feel about you. How dare you even invite us to go to the church when you're doing this to us? I really oppose this.
Did you state your name?
My name is Teresita Haber, and I live at 1140 Congress, right behind the doctor's house, right? Just one house before the church.
All right, thank you for your input. Good morning.
Good morning.
You can pick the mic up. That bends.
Okay, yeah. My name is Roger Beam. I'm at 21049 Iliad, right beside Walter. If I think the proposed location, I would walk out my door and it's going to be 60 feet away from me. They've even downplayed their amount of feet it should be away from you. Now they recommended 1320, which is a far cry from 60 feet. I'm a retired electronics engineer, and the radiation levels have not been fully studied by the FDA. For that reason, it's because cell phones took off so quick and everybody wanted them that they didn't have time for adequate studies, information to be laid out. This 5G is really an Orwellian technology, can be used for evil purposes. Very ironic that a church is proposing to do what could be used evil and control against us. It can be used for crowd control. It can be turned up and actually melt your skin or make your blood almost boil where you have to leave. It can control a car that could go out of control, run into one of the houses. Anything can happen with it, okay? It's at a much higher frequency currently than 3G or 4G, and therefore it can travel less distance but it's extremely more dangerous. It's at the frequency level of the military. It will effectively turn our neighborhood into a microwave oven with the door open. Okay, and it shouldn't be allowed in a residential neighborhood that's, you know, peaceful, quiet, and just, you know, just a nice outlook all the way around. And it will negatively affect our safety and the quiet and simple neighborhood in which we live and enjoy the peacefulness that we have there. And there's just simply no reason for it. My lawyer friend back there stated that the tower existing can be upgraded to 5G, and it absolutely can. So this proposal is just preposterous in that nature to even attempt to do it in a neighborhood residence when it doesn't even need to be done. So I urge you guys today to reject this, you know, on the basis of public safety, because there is enough radiation that can cause adverse effects on the human body. Thank you.
Did you sign in, and have you been sworn?
I have.
All right, just sign in then. Appreciate that.
I'd be glad for any questions for me from anyone else.
Does anyone else have anything else to offer that we haven't heard yet? All right, then why don't we, next would be the chance for the applicant.
Close public comment.
Pardon?
Close public comment.
Oh, we'll have to close the comment. All right.
I request public comments be closed.
We have a motion to close public comment. Do we have a second?
Second.
All right. All those in favor of closing public comment?
Aye.
Aye.
Anybody opposed? All right. Public comment is closed. Now we will have, we'll ask the applicant if they'd like to come back up, or their representative, to offer any rebuttal evidence and make any closing statements.
I waited until the end of public comment rather than having to stand up every time, but at this point I would like to lodge an objection to any testimony that was received with regard to health effects of this radio tower. Section 332 sub C sub 7 of the Federal Communications Acts preempts and prohibits consideration of environmental effects of radio frequency emissions, including health impacts of those emissions, if a tower is going to operate and emit radio frequency within the limits established by the FCC. You heard the testimony of Mr. Keene. During his testimony, he stated that this tower will operate and will emit radio frequency within the limits established by the FCC. Therefore, testimony about health impacts are not allowed and are not allowed to be taken into consideration by you in this hearing. And so I am lodging that objection and hoping that you will take notice of that federal law that preempts your consideration.
What does that tell you?
You heard much testimony today. It is very clear that the neighbors all object to a tower in this area. That testimony is not unexpected. At 30 years as a land use attorney, pretty much neighbors object to anything, any type of change that is being proposed. In this situation, their objection is that this is a residential neighborhood and a tower is inappropriate. Put it on 41, put it up in Northport. The reality is, as you heard testimony from Mr. Keene, that they look within an area that can be served. The tower only carries, and the signal only carries over a certain area. So if you say, simply just put it in commercial areas, you would have no residential areas that had cell service. And contrary to some of the testimony that you heard from people who said everybody told you that their service is fine, you actually heard testimony from several of the residents that their current cell service is not fine. Ms. Giroir stated that they rely on their landline for emergency calls for her husband because they cannot rely on the cell phone service in the area. Secondly, what I would like to talk about, most importantly,
Ladies and gentlemen, please don't interrupt the public comments time has been concluded, and it's time to listen to you can stay and remain and listen to the remaining part of this hearing. Please don't interrupt.
What is for your consideration today are 3 criteria for approval. Those criteria are, is it consistent with the comprehensive plan? The comprehensive plan designates this is in the urban service area, so it's an area designated for the provision of urban services like water and sewer and communications services. The comp plan states that it is a low-density residential neighborhood and provides a list of uses that are allowed. Among those uses are public services. Public services doesn't necessarily mean owned by a public company. It's things like the poles that FP&L puts up to provide street lighting. That is a private company, FPL, but it's providing a public service. Similarly, the cell towers are providing a public service. They are providing communications equipment that many, many people, if not most people, rely on today for provision of their and functioning of their cell phones, iPads, many other applications. So this is providing a public service, and public facilities are expressly permitted within the comprehensive plan. So it is consistent with the comprehensive plan. The second criteria is whether or not it is compatible with the neighborhood. Compatible is a specifically defined term that says, is it capable of orderly and efficient integration into the neighborhood? It doesn't say, do the neighbors like it? Are the neighbors going to be able to see it? So we need to look at this from an evidence-based perspective. Is this capable of orderly and efficient integration? It is beneath the height required to have a light at the top. It will not have a light at the top. It emits no noise. Traffic is less than if you put up a single-family home because it is just the service vehicles that come on an intermittent basis. There are not impacts that would render this incompatible with the neighborhood from a perspective of orderly and efficient integration. That is the second criteria. And the third criteria is, will it have an impact on the health, safety, and welfare of the community? Again, we talk about the impacts, that there are no there are no impacts from light, there are no visual impacts from noise, there are no impacts from traffic, and most importantly, we talked about, and we have provided as part of the record of this hearing, the analysis from the structural engineer who looked at what would happen in the unlikely, and that's his words taken directly from the report, in the unlikely event of a tower failure, that it is designed so that it buckles at a particular point and falls in a particular manner, and the conclusion of that structural engineer is that that would occur within the footprint of the building itself, of the compound itself, 60 by 60 foot footprint. That is your third consideration. The final consideration is a consideration of whether or not there are other towers where there is where 5G equipment could be reasonably co-located. Reasonable is not defined in the code. What you have is testimony from the attorney calling your attention to a letter that her firm provided that had attached to it an affidavit from Brooke Irby, who she indicated and confirmed is the site marketing manager for the owner of the SBA tower. When we spoke about that and I asked if she was an engineer, a structural engineer, an engineer of any kind, the answer was no, but that she had consulted with engineers. So her affidavit that it is capable of co-location is not based on her personal knowledge or her personal information. It is based on the knowledge of others who did not provide an affidavit and who are not here and available for cross-examination. Most importantly, you heard the information from T-Mobile's radio frequency engineer that the current tower as it exists today cannot accommodate 5G equipment. It cannot even accommodate upgrades to 4G equipment because of its size and because of its design. It may be able to be modified, but we do not know that today, and therefore you cannot take that as evidence that there is a reasonable ability to co-locate as I stand before you today. We do not know if they have an ability to structurally alter the tower. They have not done that structural analysis at this point. We do not know if the special exception can be approved, if they can meet the criteria for a special exception. It is not reasonable to assume that if all of these things happen, then they can co-locate, and therefore we can say that that co-location is possible. There are too many unknowns and too many variables that are in effect right now. Additionally, you have the opinion in letters that were provided, I believe, to, did you provide, Sean, let me confirm, have you provided the letter when they originally proposed the idea that because they could ask for a special exception, that would meet this criteria of reasonableness for co-location? You provided, I guess Elizabeth provided an email response to them that stated that it is your opinion based on, as the zoning official and interpretation of the code, that because as of today its special exception would not allow for outside antennas, because as of today they cannot, based on the parameters they provided, their height is not sufficient for 5G, that would not be able to be considered as something that is available for co-location. It's correct? That was the response that you provided?
That is correct.
Thank you. The testimony that you have before you today, the competent, substantial evidence upon which you must base your decision today, establishes that this application has met the 3 general conditions and the 1 specific condition for communication towers. Based on that, it is your duty to approve the tower today. Thank you very much for your time.
Oh, Counsel, does the attorney that presented a case have the opportunity for a last closing statement?
No.
And I beg forgiveness, I'm filling in his chair today, so I want to make sure that that all the protocols are covered.
May I ask a couple more questions of the engineer, the T-Mobile engineer?
Yes, you may, sir. You may recall witnesses if
Back
you
up
wish.
Patrick Keenan. Just a reminder, we also have a structural engineer who is available to answer questions as well.
Sir, the public comment section is closed. We're calling witnesses at the request of the panel.
Sir, they're the applicant. They have the right to do this, and we'll ask the questions. All right.
My first question
Patrick Keane
is,
speaking.
Are you familiar with this modification process that is done to towers?
I'm familiar with tower modifications. That's not my area of expertise, but I have been party to site locations where we did do modifications to a tower to accommodate new equipment. That I have.
And is there any compromise placed on you and what, your particular coverage arrangement and so on by operating from that tower as opposed to the one you're at or the one you want to put up?
The unipole tower, the flagpoles with the canisters, that definitely imposes constraints on our technology deployments. That's absolutely true. It does affect the power levels, the coverage footprints. So, for us, in order for us to deploy advanced 5G services, we can't enclose them in a tower like the one in question.
Yes. Okay, thank you.
Thank you, sir.
I have a question. Are you aware of the length of the tower, the height of the tower on Vizcaya?
The tower in question we're talking about modifying?
The other tower on Vizcaya. Are you familiar with the height of that at all?
It's 100 feet tall. I think our antennas are at 97 feet. Or maybe I think our antennas are at 97 feet. The 4G antennas.
The one on Vizcaya?
Yes.
Thank you.
Thank you, sir.
Mr. Donor, did you have questions for the structural engineer about the modification process?
No, I've got a good enough answer.
Ms. Waxler, have you closed your...
Yes, sir.
Okay, thank you.
My comments are...
Thank you very much.
We'll bring up staff now.
Thank you, Sean Cullen, planning zoning official again, since it's been a while since I said my name. After review of the site and the application requesting this special exception, it is staff's professional opinion that the proposed special exception to allow a 125-foot communications tower does meet the 3 criteria for granting of a special exception. Staff notes that each special exception request is reviewed on a case-by-case basis, and the decision of the Board of Zoning Appeals does not create a precedent. If the Board of Zoning Appeals decides to approve the requested special exception, staff recommends the following conditions be adopted as conditions of approval to ensure that the use is in compliance with the purpose and intent of the zoning code. The recommended conditions are as follows. 1. The special exception as approved by the Board of Zoning Appeals is to allow a 125-foot tall camouflage monopole communications tower with a 5-foot lightning rod and 3,600 square foot equipment compound located in the residential single-family 3.5 zoning district, generally as proposed in the application and as shown on the concept site plan labeled Exhibit L and compound plan labeled Exhibit N, and extends only to the land included in the site plan and legal description as submitted with this application. The concept plans submitted as part of this application are for illustrative purposes only. The total overall height for all elements of the communications tower, including the lightning rod, shall not exceed 130 feet. The applicant shall obtain all necessary permits and approvals as applicable to this development, including but not limited to building code review, environmental review, stormwater management, vegetation removal, fencing, and landscape plan approval. As shown on the concept landscape plan, Exhibit Q, a minimum of a Type D landscape buffer with an 8-foot tall opaque fence or wall is required around the perimeter of the equipment compound. 5, the special exception is granted for a term of 3 years from the date it receives approval from the Board of Zoning Appeals. However, the special exception shall not expire if the owner commences the proposed development on or before the special exception's term expires. And the final one, any major changes or additions to the special exception shall require modification. Minor changes or additions, such as accessory uses or structures, may be approved by the zoning official. Thank you.
Does anyone have questions? I have a question. Are you familiar with the height of the tower on Vizcaya? Would you know offhand what that is?
I know that it's approximately 90 feet tall, and it is a monopole with no outside antenna.
Well, at this point, I have no questions, so if anyone wants to entertain a motion for or against the adoption of this special exception?
Okay, I move that SC 22-010 be approved based on the Community Development Department staff report dated June 1st, 2022. The evidence presented at the hearing and finding that the applicant has met the required criteria for granting of a special acceptance is listed in recommendations 1 through 6.
And we have a motion to approve, which would include the recommendations as listed in the staff's report. Is there a second?
Second.
All right, it's been second. We'll open it up for discussion.
Okay, I believe that the tower at 1365 will not be adequate. It's my opinion.
Any other discussion? Yeah, I have some questions. Sean, special exception points us to section 3968 communication towers, and one of the provisions there, co-location requirements, says alternate support structures to which an antenna may be attached include but aren't limited to commercial. No, wait, I'll make sure I'm reading the right one. I'm sorry. 3-9-68, section B2. Co-locating on an existing tower or alternate support structure, which must be modified or reconstructed to accommodate the co-location, shall be considered a permitted use and may be modified or rebuilt to a taller height, not to exceed 40 feet over the existing tower. That's why I asked the question, how tall are the current? You said 90, the expert, or the technician said 97. That means that they can rebuild, if I read this right, that could be rebuilt to 130 feet as a permitted use and not even have to come before us. Isn't that what a permitted use is?
That is correct, but they would not be able to have the external antennas due to the fact that it was a specific requirement of the special exception that there be no external antennas.
So if it goes from special exception to permitted use, that restriction still applies?
Yes, that section of the code refers to the ability to add the extra 40 feet. As technologies, change, the heights typically need to go up higher, and that is how it's been read and determined by myself, is that the special exception still stands. They can reconstruct it with new technology. They can increase by 40 feet, but they must also adhere to the requirements of the special exception. If that to be read any other way, somebody could come in and say they're going to do a minimal tower and then by right go in and almost double the size of it. So again,
but that's a site that already is there within a neighborhood, and the only issue would be external antennas.
That is correct. That condition of the special exception specifically prohibited external antennas.
Because I heard testimony that, well, we don't know if we'd approve it, and there's a lot to be considered. It seems like the only hurdle at that point would be, and if we were going to approve this, it would require an external antenna, which all 5Gs now require, at a site that is less intrusive to the neighborhood. That's what I just want to point out. It's already there.
Understand. We have to look at what their availability is today, because again, these folks or other folks may be in this room for an application to amend to have external towers. That's something, and you may deny that, you may approve that. We can't withhold moving forward on an item with those assumptions.
And I realize what Commissioner Teseo did say. In your report, when you say could or say unlikely, I've asked this several times throughout the years. Why aren't you more definitive? And your answer is, staff's answer has always been, because it's opinionated and the final decision rests with us as whether it could or is likely or unlikely to meet these three criteria, which our function is more than just ministerial. If it was, it wouldn't be needed. Some of the other things I heard, blinking light, I don't know if it requires one. And I'm saying this because I want to let the audience know that I've looked at this. All right. Tax status, that's an issue for the IRS. They're leasing a piece of land. I don't know what that would be worth if they didn't qualify for that 60 by 60. They have to pay taxes on it, but that's not an issue before us. Motive and the money, it's not an issue before us. We don't decide up or down based on a moral issue or what their motive is behind there. And I'm responding to this because I want to let you know that I've listened to what you say, and we all have. Multiple uses. It's a question I have for staff. If something like this is permitted, can they then put, I'm sure there's a limit because of our frequency interference, but I know, where I was police chief, we had towers and there were several users on them after they went up, including our own, especially as we digitized and we needed more coverage. Is multiple uses something that would have to come before us, or once it's up, they're permitted to do that?
Correct. Once it's up, they can co-locate. That is a requirement. So if they were able to co-locate on the other tower, say it already met the requirements, you wouldn't be seeing it. They would just be submitting for a permit to attach the antennas.
But would that then be the same requirement that the antennas be inside the tower?
Yes, sir. I'm just using that as an example. If they found a way to fit it in where it worked inside, then they would just come in for a building permit.
But right now, it's external. So if 5 other or 6 other companies or public safety needed that tower, those would be external antennas, correct?
For this proposed one, yes, they could be external.
And it wouldn't have to come before anybody's permission?
That is correct. If you approve this tower today, then they would be able to, T-Mobile obviously is the tenant that is the initial tenant. AT&T could submit an application to put their antennas on, Verizon, County Public Safety, and none of those would come before you, because once a tower is granted, they have the ability to put on those other antennas so that you don't have the proliferation of every provider having to put up their own separate antenna.
And that leads to the issue that we've heard about and read about, aesthetics. Is that a restriction that we could legally impose if we chose to?
You theoretically could, yes.
But putting that aside at the moment, I've heard the argument it doesn't belong in a residential area. Unfortunately, the county does allow things in residential areas, including schools. We just approved last month a public works facility in a residential area. Those are the special exceptions. They are permitted, provided they meet the 3 criteria. And I'll be honest, there's 2 I have issues with. I do take issue with the 3rd one, detrimental. We heard testimony that, well, the house sold for more. You could have a house today, probably with no roof, and it's going to sell for more. That's just the market. But we also heard testimony that from the National Board of Realtors. And by the way, I'm a licensed realtor in the county. I think it would have a detrimental effect. And that's something for us to consider. But it is part of the statute, and we are allowed to have that opinion. And the other issue was, again, about the co-locating. It's just my opinion that because of the proliferation of all this, and I understand the need to convert to 5G because by the end of the year, your alarm system may not work. The panel inside has to be converted to 5G. I just had mine done yesterday. All right. They won't be taking the 4G transmission anymore by the end of the year. But it has nothing to do with where the tower is placed, if there's an alternative site. It's just my opinion. I believe we should exhaust all alternate possibilities and relying on the county's own code that co-locating could be a viable option, even if it means rebuilding, but there's already a tower there. It's not something new coming in. That's just my opinion.
Mr. Chair.
They still have to go with us, but there's already one there.
Mr. Chair, if I may. Mr. Chair, if I may. I just want to make sure that the board's aware that there is a code provision that would require that an increase in height of an existing tower would still require a modification of the special exception. It's not just Sean's opinion, it's also a code provision. So I just want to make sure you're aware of that.
No, I am aware of that. My point is...
So there is no valid application even in the county system for that other, excuse me, that other potential co-location. As a matter of fact, does not exist.
Yes.
It's just an allegation made by a witness.
And as it was pointed out, another 80 or 100 people can come in, but they'd be objecting to the rebuilding of a tower that's already there.
I don't know, is that a rhetorical question? I don't know the answer to that.
No, I'm saying it'd be a different situation than we're currently. But that's just my opinion. I'm 1 vote out of 3 today. Any other discussion?
Well, I sort of feel that as we watch the wireless world increase and have more significance in our own lives, it becomes almost like sewer and water. And if you need it in your neighborhood, you're going to have to put up with whatever it takes because, this is just a fact of life. So I hear what you say, but I am not overly influenced by it.
And I hear what you're saying, too, and we have approved these. All I'm saying is that this case is unique. There is a site nearby that could substitute for this one possibly.
Well, what I heard was that would compromise their coverage somewhat.
No, I
And with a background in this field, I believe he's telling me straight stuff.
Yep.
Any other discussion?
No.
All right, then we'll move the question. All those in favor of, we have a motion before us to approve the cell tower, and along with the restrictions as, or the recommendations as outlined in the staff report. All those in favor of approval signify by saying aye.
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 No? I'll vote no. So it passes 2-1.
Okay, it's wrapped up.
Really didn't give us enough time to prepare legally to come up with that same thing. And we really didn't have the opportunity.
Enjoy your money.
I'm fine.
Good.
Yeah.
This is owner, he's our district.
All right, folks. No, we have to continue the agenda. I have to continue the agenda. You know, if you want to talk to each other, please step out into the lobby. Yeah, all right. Okay. Let me go back to where we are now.
Well, I know. Sir, I need you to leave the chambers, please. Yes, I will.
All right. The, yeah, if we could, please, please, can you hold the conversations? We have to conduct business. That's why if you have to, please step out. Appreciate that. All right, next on the agenda, just public comments in general. All right, hearing none, staff comments.
Thank you. This was a good meeting. Thank you very much. It's always good when we have a lot of public comment and we can hear the people, whether it gets approved or not. It is always good to have that public participation. We will have a number of items. I don't remember that number of items for the July hearing, but other than that, have a great day.
And thank you for your detailed presentation today, and answering all of our questions. Next meeting is July 13th. Having no other business or objections, we'll stand adjourned.